Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, February 23rd. We have 9 bills on the docket. We're going to start off with Senator McCray with Senate Bill 486. We'll then move to 645, 535, 462, 792, 851, 797, 686, and then we'll wrap up with Senator Sidnor with Senate Bill 478. So with that, we'll start off with Senator McCray with Senate Bill 486. I understand that Senator McCray's Chief of Staff is here to present the bill. Welcome. And whenever you're ready, you could come to the podium. That'd be great. Thank you.
Hello, everyone. My name is Tamika Winkler. Hello, Chair, Vice Chair, members of the committee. My name is Tamika Winkler. I'm here before you on behalf of Senator McCray. He sends his apologies that he's not able to attend today. I'm here to introduce SB 486. For SB 486 is requesting for 2 assistant sheriffs and 4 social workers, and is no fiscal note.
All right, we're going to start with Senator. Let's do the witnesses first, and then we'll do the Senator West has a question. Thank you. Whoever would like to come up next.
Good afternoon. My name is Lenore Dawson. I currently hold one of the positions of assistant sheriff that we're actually requesting within this legislation. I have 15 years of experience working as a civilian within a law enforcement agency. I hold a master's degree in applied psychology, conflict management, and negotiations. I am also the public safety chair of the NAACP for the Maryland State Conference. In my current position as Assistant Sheriff Special, that's how I have to be classified until this legislation is passed. I manage human resources, a $23 million budget, communications, community affairs, and our fiscal department. Additionally, I have been tasked with the responsibility of managing and implementing our body-worn cameras, improving technology, and providing oversight regarding police reform and accountability. We are in need of these 2 assistant sheriff civilian command positions in order to retain high-level professionals with the expertise needed to manage the administrative functions within our agency. The other assistant sheriff would be responsible for fleet management, procurement, and quartermaster. Excuse me. These are much needed positions to ensure that we at the sheriff's office have the capacity to run and maintain a 21st century sheriff's office in order to support the citizens of Baltimore City. Thank you.
Good afternoon. Thank you for allowing me to testify, and I appreciate your time. So I am Sheriff Sam Cogan. I'm the Sheriff of Baltimore City. This bill does 3 things. One, it creates 2 assistant sheriffs. You heard from one of them, and that's incredibly important to have the oversight we need as we bring the Sheriff's Office of Baltimore City into the public safety solution of Baltimore City and expand. We're going to need people like her and our other assistant sheriff, David McClure, who's in the room, special. We need them authorized so that the law enforcement officers can work on law enforcement matters, and we have expertise to implement police reform and also implement the logistics required to run a modern sheriff's office. So that authorizes that. There's no fiscal note. They're already working as special. It just makes them a permanent position. The next thing about this bill is it creates 4 social worker positions that I can use to help people connect with services before they're being evicted and after they're evicted. That doesn't happen now. What happens now is the sheriff's office goes out and they tell people they have to get out of their homes on these warrants of restitution, and they move them down the street, and there's no real service aspect of that. We need to create a service aspect in Baltimore City where we can help people prior to the eviction connect with services. I hear all the time that I couldn't apply for rent assistance because I didn't know how to read or write. that could help us connect them with those services that are available. And also, after they're evicted, I want my deputies to be able to have the social workers in my office. They can pick up the phone, and if she was just evicted, do you have a place to go? And she says, no, I don't, I'm in desperation. They can immediately from the field connect them to a social worker who can connect them to homeless services, who connect them to Catholic charities, who can make this bridge in the field. That's something that doesn't exist right now. I think it will be the first time a sheriff's office is doing this in the state of Maryland. It's incredibly important. This bill would authorize us to have these 4 social workers on staff. I don't know how to make these connections. I'm not a social worker. We just need that expertise brought into the office. And finally, it opens up our positions. We have a maximum cap right now. If the mayor wants to allow us to take over a service, we have to come back to you and say, hey, I need another 3 or 4 deputies. This connects it with funding rather than puts a maximum cap on that. And I can answer any questions anyone may have.
Well, thank you, Mr. Chair. I actually thought Senator West was first, but I'm happy to welcome and give greetings to our sheriff for Baltimore City, as well as 41st District resident and constituent Lenora Dawson. I just want to say thanks for coming and welcome. There was no opposition to this bill in the delegation. It is a local bill, and you should have a letter in the file. And I just want to say that we're excited about these new changes. They sound very reasonable to me, and I have no question, just a comment. Also, that we deal with a lot of these issues with landlord-tenant issues, evictions, law enforcement issues, and I've always found you to be very reasonable.
Thank
So I'd love to have your weigh in on some of these additional things that we deal with this session. Thank you.
Thank you. And we'd love to work with you as well.
Thank you, Mr. Chair. I'm mystified. Why does the Maryland General Assembly have to pass a law in order for the sheriff's office in Baltimore City to hire a couple of new assistant sheriffs?
Yeah, well, so that's one of the things this law does. Like, so you're passing a law, so you don't have to pass other laws.
Why can't Baltimore City's going to pay for them? Why can't Baltimore City just put in the city budget money for some additional sheriffs and do it that way?
Right. Well, so they can't, because the current law says there should be a maximum of 103 sheriffs. That's what it says under state law. And so we're asking you to change that state law to say exactly what you just said. If the Baltimore City wants to fund us, then they can. So this is tied rather to a state law that says there's a maximum cap that we may appoint.
I hear you. I'm asking a broader question. Why shouldn't
Sure.
we pass a law that says it's up to Baltimore City how many sheriffs, assistant sheriffs there are? And why should you have to come down to the General Assembly every time you want an additional assistant sheriff and get us to pass a law? See what I'm saying?
Not really. I think we may be saying the same thing.
Okay. Well, I'll talk to Senator Carter about that. Maybe
Gotcha.
have a bill next year to take you off of us and let the city make decisions about the sheriff's office.
Understood. I think this bill actually does that, what you're saying.
Oh, okay. Thanks.
All right, sorry, Senator Folden, sorry. But Senator West, if you just go to page 2 of the, well, we'll talk offline, but go to page 2 of the bill is what he's talking about, to give them more flexibility to move forward without us.
Yeah, because it's a state office, so that's why. But hey, Sheriff, thanks for bringing this forward. And I guess, is it Assistant Sheriff Special? Okay, there we go. Thank you all for coming out. So I just am curious, and I want to be sure on this. I really like the bill. I like what you guys are doing, especially in light of, the times that we're in. Does it also help? And I don't want to presume anything, so I'm asking. Does it also help in that when the eviction is served and they're actually moved out of that facility, to protect their goods that they have or allow them an expedited movement of their property? Because, being in law enforcement and seeing a lot of, unfortunately, a lot of these evictions occur, we have people that they see the posting on the door. They know when the eviction's happening. And it almost becomes like a feeding frenzy because they're waiting for that day to come, and they put all their property out on the street, on the curb, and then people come and take it. So would this also help with remedying that, so they're not losing things that they have to then replace and seek out other services?
So I believe that one of the things that we can do with these social workers is to make sure that we're notifying people, and that people really understand that at the day of the eviction, if their property's left in the premises, that it's at risk. Yeah, go ahead.
I understand that, Sheriff. What I'm saying is maybe I need to word it this way. Would you be amenable to adding some language in there that would give at least some type of vessel to create or add to what you're doing, which I think is a great policy, to allow them with some other relationships that are built into the community, even a temporary storage, so that they're not losing their property. Because the problem is when you become indigent, you lose your home, and then you only have a finite amount of property. And when people come and take that property, because once it's on the curb, anybody can get it because it's open, right? And that's the bad part. That's my problem that I have with the way that we do some evictions. Would there be something that we would consider, or you would consider with networking within the community, that there would be a temporary holding facility for those times instead of just throwing it out on the curb, so that at least they're not losing everything and rebuilding on an already obvious reduced income level concerns?
Sure. In Baltimore City is different than anywhere else in the state with the failure to pay rent cases. The property is actually deemed abandoned at the time of the eviction, and they've already lost their property at the time of the eviction. And that's the way the law is written in Baltimore City, with they call it a lock and leave. That's where that's happening. So there was already a negotiation with within the landlord tenant community, with advocates and with whatever some years ago, and they determined if there's an additional notice that's posted that tells them the exact date and the time of the eviction is posted on the door, then once the property's locked in there and abandoned. Right now, whether I think that's a good idea or not, or whether I think that it would be helpful I absolutely be helpful.
I don't want to belabor it because I know this is a very much more specific thing. We can talk about those on a sidebar. I know that you had mentioned it, so I wanted to bring it up, but this isn't what this bill is about, as I understand it. So let's get this part done, but I would like to have.
I would talk to you about.
I would like to
anything
have
else.
a problem solving or a think tank to address that. Thank you.
Great, thank you.
Additional questions from the committee? Seeing none, thank you both very much. Thank all three of you very much. All right, with that, that'll conclude the hearing and the testimony in the hearing for Senate Bill 486. We'll now move on to Senate Bill 645, Senator McCray. Senator McCray's chief of staff is here to present the bill. And would you like to call the panel?
Yeah.
Sure. Here you go.
For you. Hello, everyone. My name is Tamika Winkler again. I'm here to introduce Senate Bill 645. Senate Bill 645 authorizes the mayor and city council of Baltimore City to set salaries for deputy sheriffs and other specified employees. Senate Bill 645 alters designated provisions relating to collective bargaining. This allows members of the sheriff's office to use their voices during the collective bargaining process to negotiate wages. I humbly ask for your assistance in approving Senate Bill 645. Would you like to go? Or? Thank you.
Mr. Chairman, Mr. Vice Chairman, honorable committee members, my name is Ari Plout, and I'm here on behalf of the State Fraternal Order of Police in support of Senate Bill 645. I want to thank Senator McCray and Ms. Winkler for sponsoring this bill. As Ms. Winkler just explained, this bill is about collective bargaining for sheriff's officers related to hours, wages, and salary. A bill was before this body a few years ago with the intent to allow this same collective bargaining, but inadvertently was not included. And we would just ask to complete what was tried a few years ago. We have tried reaching out with the opposition, and we will continue to do so. We are definitely willing and able to continue to those conversations. And at this time, I would defer to Mr. Ball to my left, who is a labor counsel for the FOP. And I appreciate your time, and we ask for a favorable report. Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is Chaz Ball. I'm a partner at Slocum-Belsky Wiener & Davy, and the firm represents FOP 22, which is the bargaining unit for the Baltimore City Sheriff's Office. And we're labor counsel for the bargaining for FOP 22. I don't think there could have been a sort of better introduction, it was a few minutes ago now, to what we're here for than the fact that the residents of the city of Baltimore ultimately pay for the Baltimore Sheriff's Department. That's a reality. And our argument here is that, you know, we're very proud to have this sponsored by Senator McCray, as a labor background himself. This is a labor issue. When this legislation was first passed in 2021, it was done with the idea that the city of Baltimore would be able to bargain with the Baltimore Sheriff's Office in order to figure out wages for the sheriffs, because the city of Baltimore ultimately foots the bill for the sheriff. So they should have the ability, as opposed to Annapolis or as opposed to the governor, to set the wages and to be able to make that determination. Following that point in 2021, Labor Council, as well as the city solicitor's office, went forward towards collective bargaining. And at some point, there was a hang up where there was a question as to whether the language of that legislation specifically allowed for the bargaining of wages. And obviously, when we're talking about collective bargaining and the conditions of employment, one of the most important conditions of employment we're going to talk about are wages. Once that issue came up, the FOP 22, as you know, tried to come to some resolution, but the city sheriff's office took the position that there was some issue in the legislation that didn't cover it, and ultimately the wages were determined by the state and the governor, as opposed to the citizens that actually pay for the wages of the sheriff's office. Thank you.
Good afternoon, Chair, ladies and gentlemen. My name is Josephine Zillman Georgie. I am the president of Lodge 22. And we were here several years ago, and we did get the collective bargaining bill, but somewhere along the line, merits and steps were put in place or were on our bargaining contract instead of salary and wages. And we have, when we went to negotiate, we realized this. So we're now asking for an amendment that it would be added so that the deputies, lieutenant sergeants and deputies for the Baltimore City Sheriff Office are allowed to be included in salary and wages when we do bargain for with the sheriff and the city for our salaries. And I would appreciate if you would help us change or amend that mistake. Thank you.
All right, thank you all very much. Questions for the panel? Seeing none, thank you all very much. That'll conclude the testimony for the proponents of the bill. We'll now switch to the opposition panel, and we have Mr. Hayes. Sheriff, come on up.
Thank you for letting me testify again. So it pains me to have to stand up here and oppose this bill, because I definitely want the deputies to get a raise. They deserve it, right? And I'm also very much for collective bargaining. And I was actually supported the bill that they're talking about here. I was at the table to try to craft it. The issue here goes deeper than this, and it's a political issue, and as often is, and it's nuanced. So as I won the primary election, and I had no opponent, this MOU that they're talking about was still unsigned and still hadn't been ratified. And the FOP chose to move forward against my strenuous objections and ratified their contract, their labor contract, for 3 years, which covers almost the entirety of my term, 1 month before I came into office. And in this bill, in this contract on page 10, there's clearly something on compensation that they have in the labor contract. And it talks about the state steps that they're talking about. Now, I begged them not to do this, right? I said, please don't, right? We can find a way to get you guys raises and compensation. We can look at this. I believe you guys should have parity, at least with the police department. Let's try to deal with this. And instead they moved forward against this. And like I said, a month before I came into office, ratified, voted on, and now they have a 3-year contract that's very clear, right? This is their MOU for 3 years, talks about compensation. And the other thing that happened is the FOP, prior to introducing this legislation, failed to speak to me or my office in any kind of way about this legislation. It just dropped. And I just would say that adds insult to injury, and it's not the way to do things. That's just not the way things should be done. Also, the premise that we can't negotiate wages, I think is debatable. And it has to do with whether or not the sheriff has spending authority in their own budget. And so this hang up that they had is an undetermined issue. If the sheriff has spending authority within their own budget, which I believe that we do, then this isn't in control of the mayor, and we could have negotiated wages within the contract. So this is I think there's problems on multiple levels, even problems with the legislation that really deals with the command staff instead of the deputy sheriffs, where we says we're going to change it from the city to the Department of Budget and Management. So for all those reasons, unfortunately, I think we need to take some time internally. I need to work with my FOP. My FOP needs to work with us, and we need to come back next year with a better bill in front of you. And I can answer any questions.
Thank you, Mr. Chairman. I'm looking through the notes here and the testimony provided. Is there not a delegation letter of support? Okay. That's all I have. Thank you.
Thank you.
Sorry. All right. It's just unorthodox to come up with that sign. You're not signed up, and
Okay.
we got it. I mean, you are my cousin and everything, but I can't show that type of favoritism, but come on. All right. All right. That's actually true. All right.
Sorry.
Yeah. I'm not though. Hey. All right. With that, that'll end the testimony. Oh, sorry, Senator Washington.
Yeah, thank you, Mr. Chairman. I do have a question for the sheriff. Yeah, I wondered if, because I don't know who sets the salaries. This bill is so that the Baltimore City Council and the mayor sets the salaries for the deputy sheriffs and for the sheriff. Is that correct? That's in the bill?
It says the city,
The city, right.
except it's applied in the wrong place. And so it doesn't. It means where they put it in the bill as it currently reads, it means they're applying it to the command staff, the assistant sheriff, not to the deputy. So it's actually incorrect. But I think the intention was to say that the city council sets the salaries.
Got it.
But see, that's not been my understanding of any sheriff's office. It's that the sheriff controls what, as the appointing authority, what happens within their own budget.
Right.
And if that's true, then as of today, we can negotiate this, and the bill we originally passed makes sense, and then we could have done that.
And for a police department, a chief of a police department, they set the budget for their command staff as
Correct.
well. Is that right?
Yes.
Not the city council or the county council.
Well, they set it, and then because it's a certain expenditure level, they take it for Board of Estimates approval, but
Correct.
they're the ones who are recommending it.
Got it. Thank you.
All right. Seeing no further questions, thank you very much.
Thank you.
And with that, that'll end the hearing for Senate Bill 645. We'll now move on to Senator James with Senate Bill 535. Senator James, you're up.
Yeah. Good afternoon, Mr. Chairman, members of the committee. For the record, Senator Mary Delaney James, and I'm delighted and really honored to present Senate Bill 535. It really is a simple bill, but it addresses an infrequent but really important issue to the disability community and the amazing dogs that help them live fuller lives. There is no opposition to this bill that I know of. And I did check around, but there is a letter of information, which I'll address at the end of my comments. I think you all know the current law is that between the ADA and the Federal Housing Act and some Maryland disability rights laws, people with disabilities can't be discriminated in our state, generally speaking, and in housing. And thus really, service dogs and guide dogs can come into rental properties and houses, and landlords aren't allowed to charge extra fees or costs, but landlords do have the right at the end of a tenancy, to assess damages if the dog has created a problem. But what Senate Bill does do, because Senate Bill 535 does do, which is something that's not already explicit in Maryland law, when these service and guide dogs retire, extraordinary to me, there are some landlords that have a no pet policy
that have allowed them under the, the anti-discrimination sections, but because there's nothing explicit, because they have a no pet policy, they will turn around to the disabled community and either try to charge them money, extra money, even if the dog hasn't done anything, or require them to get rid of the dog. And for this community, sometimes they don't have a family or a friend. So what happens? The dog ends up going to a shelter and they can be euthanized, right? So the community has asked me for you all to consider protecting this narrow but important issue. And all this bill would do is once the dog is determined retired, and by the way, that is the judgment of the handler. It's just like human beings, when we retire, it's always depends where we are in our lives and our health. It's the same with the dog. So the handlers, the owners will use their best judgment and retire the animal, but they certainly don't want the gut-wrenching emotional situation that would happen if the dog would have to be euthanized or given away. This allows these owners to continue to live and love these dogs that have faithfully served them into their retirement. Now, just really quickly, the House bill, I believe, is passed with favorable with no amendments. Am I correct? Voting on it later today. That's good. And the State Commission on Civil Rights sent a letter. There are apparently 3 or 4 definitions of service animal. I'm happy to make the bill explicitly clear that we mean dogs, and we'll use the ADA as a reference. We'll take out the word pet as unnecessary. And regarding retirement, I appreciate them diving into the details on that. But I got to admit, since there's no process for certifying a dog or licensing a dog, I don't think there's any way we can officially retire a dog, but I think we have to give some credence and support to the good faith and honor of the people involved. And let me just say to you all, can everybody that supports this bill 535, would you like to stand? Not everybody's testifying. And some beautiful service animals. All right, thank you, Mr. Chairman. I hope we get a favorable report.
Excellent. No, thank you, Senator. Do you have a panel?
I do.
Excellent. All right, we'll go, to the witness table. There you go.
Good afternoon. Thank you for the honor of addressing you about Senate Bill 535. My name is Matt Hackert. I work as an access technology specialist with the National Federation of the Blind. More importantly, I have with me Igloo, who is my 4th seeing eye dog, who was retired at the end of July last year. And just as demonstration that although I made the decision based on declining health and other factors with his guide work, that it was time for him to retire. I now find myself in some uncertain situations due to separation of family. I do currently own my home. However, I and/or my wife may be looking at renting. And so it brings up really big questions about what can be done with Igloo. If he may need to be rehomed. He and I have spent 11 years together, and he's been a wonderful guide through that time. And it would be really difficult to consider rehoming him. I don't have much in the way of family in the state of Maryland. I moved here 4 years ago, and there's just a lot of uncertainty what may happen if we have to find rental situations. So hope that everyone will find favorably for this legislation. Thank you.
Good afternoon, Mr. Chair. Hi, Mr. Vice Chair and members of the committee. My name is Ronza Othman, and I'm the president of the National Federation of the Blind of Maryland. NFB of Maryland is the state's oldest and largest organization of and for blind, low vision, and deaf-blind individuals. We maintain our independence and move about the world safely through the use of long white canes and guide dogs. The ADA, federal housing laws, and the Maryland white cane law all define what is considered a service animal and guide dog. Those laws also protect against discrimination for guide dog users, and that guide dogs are not considered pets for purposes of housing as long as they are active working dogs. But sometimes they have to retire, usually due to age or illness, but they still have several good years in them, but just cannot actively guide. There's a loophole in the law that retired service animals including guide dogs, are not protected, and no pet policies and pet fees then apply to them in housing, excuse me. Thus, the handler has to either rehome the dog, move, or in some cases, put the dog down. It's hard to rehome an older dog. It's sometimes impossible to move because the person might be on one controlled housing, Section 8, or on a bus route where they need to use to get to work every day or medical care. I'd ask you to look at the written testimony in your packet of Sherry Shirek, who had to rehome her dog or find another place to live when he retired. This was heartbreaking for both of them, and the dog ultimately died. Sherry lives in an apartment complex with a $300 annual pet fee and an additional $25 a month just to keep a member of the family in the household with her. We've seen fees as high as $300 per month in some locations. Blind and low vision people are often on fixed incomes, and so this is beyond their means. I'd also bring your attention to the written testimony of Stephanie Flint and Terry Nettles, both of whom have also experienced this problem. For the sake of these dogs and their handlers, I urge a favorable report to SB 535, and I'm happy to answer any questions you may have.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, members of the committee. For the record, my name is Lisa Radov. I'm the President and Chair of Maryland Votes for Animals, here on behalf of not only Maryland Votes for Animals, but also the Humane Society of the United States, strongly in support of SB 535. Just want to give you a little word about the dogs themselves, since the advocates have been able to speak and the dogs aren't. Retired service and guide dogs have lived most of their lives as model canine services, citizens dedicated to service. They must undergo vigorous training to perform their duties and must be very well-behaved canine citizens to graduate. When they retire, they retain these qualities as older dogs. Plus, they're senior dogs, so they're less active, less noisy, and less boisterous. They should be allowed to live out their senior years with the senior years or the later years of their owners, free from the fear that once they've retired, they would not be welcome. By passing SB 535, we ensure that disabled people and their dedicated working service and guide dogs, when they're retired, can live out their best years. Thank you so much to Senator James for sponsoring this compassionate and humane legislation, and I urge a favorable report. Thank you.
Thank you. I'll be honest, I'm ignorant in this respect. I've never heard of a guide dog retiring, so this is something new to me. But what I'm wondering though is once this guide dog is retired, that in essence means that they're no longer being used as a guide dog. And I'm from listening to what you all were saying, essentially the way the world would now view that guide dog is now that that guide dog is a pet because they're no longer servicing their owner. Is that correct?
I actually would disagree with that a little bit. I'm sorry that word pet got in there because I think because of the extraordinary training of these dogs, and they start very young, they've been hard working, unlike other animals that are pets who've never been put through it.
What I'm trying to get at those, if they're no longer guiding, then what happens? Do we get another guide dog?
I asked that and I would let them probably, in case I misspeak, I asked the exact same question because I thought, well, what happens if you've got a retired dog
Right.
and then you get a new one? And sadly, it is very hard to replace these dogs. So generally speaking, the owner of the retired dog is waiting. And it's in a bad spot because they can't use the dog that they've retired because they don't feel confident the dog can protect them. But these dogs are long in the training and not easily replaced. So they usually have to wait several years. So the idea that you would have two, I get it, in a house. I asked them, that was my first question, Senator, and this was the answer. And if I misspoke, I'm right. Okay, well, I listened. That was what I was told, and I believe them.
Okay, and okay, so at some point that dog, and I'm trying to figure out the best. I mean, it's not that it becomes useless, but it doesn't provide that service anymore. So
not in a manner that they would feel confident going out into high-risk places, right?
Okay, would it, under your bill, would it be deemed to be discriminatory? Because I heard someone mention a $300 fee for pets.
Right.
I'm assuming if a landlord is charging a $300 fee for any animals that are kept in their property, would it, under your bill, would it be deemed to be discriminatory because the landlord would now deem this guide dog a pet? Is that what you're trying to
And
get
that-
at here?
Yes, this bill would disallow a landlord for taking that that
position.
position. And you heard from the advocates and people in the know, a lot of these people are, because of their disability, are on fixed incomes, limited places they can live, maybe because of even the design of the apartment. So it's not like a fully sensed person who can go anywhere with lots of options. Oftentimes they have limited housing options that work for them for other reasons. So it becomes very challenging to find a new place. And so again, the landlord's fully protected. If there was any damage by this dog, the tenants, the owner, the user remains liable. That doesn't change under this bill. In fact, it is reaffirmed in this bill.
And the last question is, what happens in that time when the guide dog is retired for the human who's using or would have been using the dog? What do they do?
Who, the dog or the person?
The person, I mean, because they still are in need of,
I'm gonna let.
that's what I
yeah,
appreciate that. Thank
I'm
you.
not qualified on that.
Yeah, in the interim, particularly with school trained dogs, but I imagine this applies with owner trained dogs as well. There's an expectation that they have other skills to compensate. I can still navigate using a white cane. However, my preferred method of travel is using a guide dog. And in that interim, while I'm waiting to train with a new dog, I'm still able to get around and function in the community using a white cane.
But you're essentially left without a tool that you would have had until a new dog is trained.
That is correct.
Okay, thank you. Appreciate that.
So additional questions from the committee? All right, well, sir, it was nice meeting you, but Senator, you have two of my favorite people on the panel, so it's good to be with you both. So, I know, there you go.
Figured out how
Good start. Former coworker and a good friend. So yeah, good to be here with you. All right. Excellent. With that, that'll end the hearing for Senate Bill 535. We'll now move on to Senator Folden with Senate Bill 462. Senator Folden, you're up.
Next. Mr. Chairman, Mr. Vice Chair, esteemed colleagues. My name is, for the record, Senator William Folden, District 4, Frederick County. This afternoon, I have a pretty simple, straightforward bill. This bill was brought forward last year and was passed in this committee and moved forward through to the chamber floor where it died in the House. And we're trying to re-ask for this change to the sheriff's salary in Frederick County. We have to ask as a part of, because the sheriff's office is a mandated position by state constitution, we have to come here and ask for the salary of the sheriff. Currently, the Frederick County Sheriff's salary is ranked 14th out of 24 current sheriffs, even though the population that is served is obviously in the top 6 counties and districts in the state. The sheriff's salary has been the same rate for the past 16 years. And we all know that we've seen significant pay and costs for items through and inflation over the past recent years, let alone the past 16 years. What we are asking is that we attach the salary for the sheriff of Frederick County to the pay scale of the Maryland State Police Lieutenant Colonel at the highest step. This will make all future asks of us to come forward, having it set to a set amount unnecessary, as it will adjust at the beginning of each election cycle, consistent with what that position is within the Maryland State Police. So there'll be no more need for us to come here and ask and bother you and actually waste your time. It should be attached. It's a similar responsibility. Let's just make, and this is pretty, we have a letter of the delegation support. I will say that in the fiscal policy note, I want to point out that it's inaccurate on the local effect, in that they're saying that the increases will be a minimum of 58,000 in FY 27 and then 100,000 annually thereafter. That's just wholly inaccurate. There's nothing in this pay scale that supports those numbers. The current scale of the sheriff is 125,000. And then the state police pay scale, you can see there at the bottom on step 18 is 190. So this would allow for that to be consistent across the board. The letter of delegation support is attached in your folders. And, at the end of the day, we just want to make this about the salary consistent with the job and the responsibilities, not the personalities of the people in the position, because I'm sure there's plenty of us who also got elected that would probably be happy if some of us weren't here. But we have to work together and we want to support each other in all our endeavors. So with that, I would respectfully ask for your favorable report on SB 462, and I'm happy to take any questions should you have it.
So no, I think that's the vein in which we passed this bill last time. Senator Washington has a question, and then I'll chime in afterwards.
Thank you, Mr. Chairman, and thank you for this bill. Just a quick question for you,
yes, sir.
Senator.
Mhm.
Does the salary change when this bill passes, or in
No.
June, or when is the salary?
Same thing like it would be if it were passed. It will only take effect the day prior to the next swearing in of the next sheriff.
Got it. So it doesn't
So
affect the current
It
sheriff.
doesn't affect the current sheriff. It'll be in place and ready for that one. And then if the state police were to adjust their pay scale 2 years after that, it wouldn't take effect at that time. It would not take effect until the same thing, the day before the next term would start.
Got it. Thank you.
Thank you for your question.
My question was just on procedural history. What happened to this bill in the House?
It got killed for personalities.
Mhm.
I mean, it was a
Member of this
local
committee-
bill. How many times have you seen, Chairman, a local bill get killed on a chamber floor with local support? and
Something
delegate-
different happened on this bill than that. So, did the name of a member of this committee get stripped off of that bill?
No, because it was initially sponsored.
Yeah, got it. No, I'm supportive of the bill. I'm just,
Yeah, there was,
Yeah.
it came down to personalities, unfortunately,
yeah.
and we can't do that. We can't allow for that. We all have different opinions on things, but at the end of the day, we serve the people that vote us in.
Yeah.
And we should be doing things to elect the proper people to keep us safe.
All right.
Okay,
Thank you very much.
thank you all. Thank you very
Thanks.
much.
Appreciate it.
Appreciate it.
All right, excellent. With that, that'll end the hearing for Senate Bill 462. And I'll move on to Senator West. You're up next with Senate Bill 792.
Thank you, Mr. Chair. May I ask my panel to come and join me?
Yes.
Thanks. Where are the other two? Virtual. Virtual. Oh, the other two are virtual. Okay, great. Fine. Thank you, Mr. Chairman. This is Chris West here to present Senate Bill 792. It's a pleasure to present this bill because this is my last bill for the year before this committee. So I've got one more in a different committee, but this is the last one before JPR. And this is an important bill. The laws of intestacy regarding who inherits if a Maryland resident dies without a will have not been updated to reflect modern unmarried families. Senate Bill 792 will remedy this issue. The bill allows unmarried domestic partners to register their domestic partnership by filing a declaration with the Register of Wills in the county in which they're domiciled. And then by registering, a surviving domestic partner will have the same right to an intestate share of the deceased domestic partner's estate as a surviving spouse would have had. And the inheritance tax will not apply to the amounts received. So in this day and age, there are people who cohabit and live very happy lives, but are not married. But they regard themselves in all other respects, but for the formal certificate of marriage as people who are intimate and close. And this bill attempts to give them the same rights that married couples would have in an intestacy situation. The bill also eliminates the words legitimate child and illegitimate child with more appropriate modern terminology. So if there are no minor children and no adult children from a prior relationship, this bill provides that the surviving spouse's share, or the registered domestic partner's share, is increased to the entire residuary estate. As you probably can tell, this bill was brought to me by the Estates and Trust section of the Maryland State Bar Association. This is not an area in which I'm intimately familiar. And that's why I have 3 witnesses, 1 live and 2 on screen, to help explain this bill. Let me just explain 1 or 2 more things, and then I'm going to turn it over to my witness. In the scenario in which there's no surviving minor child, but there are adult children from another relationship, the spouse's registered domestic partner share will be the first $100,000 plus 1/2 of the residue. Also, the bill covers the interests of great-grandparents and the issue of great-grandparents. They're deleted as classes of intestate beneficiaries. So as you can tell, the bill's a little complicated. I'm now going to turn it over to Laura Thomas from the State Bar Association, and she'll be joined by Alexi Burrell and Byron McFarland, the Register of Wills of Howard County, who will further explain this bill. And I'll stick around to answer questions.
Good afternoon, Mr. Chairman and members of the committee. My name is Laura Thomas, and I'm here today on behalf of the Estate and Trust section of the Maryland State Bar Association. We support Senate Bill 792 and urge a favorable report. Although this bill is titled Registered Domestic Partners, it is the result of a task force convened to study intestacy laws in the state of Maryland. The task force consisted of representatives from the bar, the Register of Wills offices, and legal services for low-income Marylanders. And we met for many hours during 2022 to review these laws in detail. The purpose of intestacy laws are to make wills for people who die without a will, as that person would have been likely to make. Data from our registers show that about 60% of Maryland estates involve decedents without a will, so most Marylanders have wills that are created by our intestacy laws. As Senator West said, our intestacy statutes were last updated in their entirety in 1974. And since then, the structure of family and the relationships of the citizens of our state have changed. Those changes require that our intestacy laws are updated to ensure that the laws are making wills for people that are most likely the wills they would have made for themselves. In my practice, my clients write wills that are very different from the will that the intestate laws would provide for them, and our updates strive to correct this inequality. The issues the work group identified with the intestacy laws are that there's no distinction between nuclear families and blended families. There's no recognition of couples who are not married, but whose financial and personal affairs are entwined in many of the same ways. Identifying the great-grandparents is costly in probate estates of modest means, including parents as beneficiaries of an intestate decedent with a surviving spouse is an out-of-date concept, and the statutes include stigmatizing terms. We urge a favorable report on Senate Bill 792, and Alexis Burrell-Rody will next provide detail on the changes the legislation makes to the intestacy laws.
You're up. We can hear and see you, so you're up.
Okay, thank you. Thank you, Chairman and members of the committee. My name is Alexis Burrell-Rody, and I'm the Register of Wills for Baltimore County. As Ms. Thomas described, the laws of intestacy become the de facto will for the majority of Marylanders, in particular, individuals of modest means. That means the laws should reflect what most people would want to happen to their assets. One of the most misunderstood and surprising aspects of current law is the share passing to the surviving spouse of an intestate decedent. The public is often confused because the spouse does not always receive all of their assets. Currently, when a married person passes away with adult children, the spouse and adult children share in the decedent's estate. Or if a couple is married for less than 5 years and have no children, the spouse and the decedent's parents share the estate. People don't expect these results, and the proposed changes address this confusion. In general, under the proposed legislation, the surviving spouse receives the entire estate. In the case of blended families, the surviving spouse receives the first $100,000 with the balance shared equally with adult children. We are doing away with the distinction between marriages of more or less than 5 years. If there are surviving minor children, whether of the marriage or not, the spouse and minor children share the assets equally. Importantly, this is not a change from existing law, and we kept this provision the same in an interest of protecting children who are not old enough to advocate for their own financial best interests. The law as it's currently written does not track with what most people hope and expect should happen to the assets. The current system leads to housing and financial instability for surviving spouses who are counting on and budgeting to receive their predeceased spouse's assets that the surviving spouse directly contributed to accumulating. These changes will lead to better protection of marital assets and a more efficient transfer of intergenerational wealth. I urge a favorable report from this committee for Senate Bill 792. Thank you.
Excellent. Thank you very much. All right, Mr. McFarland, you're up. Good to see you, Byron.
Good afternoon, Mr. Chairman. Good to see you too. And members of the committee, my name is Byron McFarland. I'm the Register of Wills for Howard County and was pleased to take part in the work group that you've heard about. I want to thank Senator West for sponsoring this bill and my partners in the Bar Association and my registers, my fellow registers who participated in this work group, because this really is an important bill and we really did put a lot of work into this. It recognizes, and I want to talk about the domestic partner piece of this specifically. This bill recognizes that many adults in committed relationships choose to partner rather than marry. Statistics show at least 7 to 8% of cohabitating adults are partnered, and we know that number will increase over time. Our laws should reflect and respect how our residents choose to orient their relationships, and that is why this bill proposes that Maryland join many other states by establishing a domestic partnership registry and explicitly provide specified benefits to those individuals who are registered domestic partners. When it comes to probate, domestic partners are treated as legal strangers for the most part. The lack of protections for the surviving partner can lead to intense conflict with the biological family and a tax burden imposed on what is often jointly accumulated wealth. We propose that any two individuals who are not otherwise partnered or married may apply to become registered domestic partners with their local registrar's office. We would charge a nominal fee and maintain a statewide database of these partnerships. It would put a surviving partner, as Senator West said, on equal footing as a surviving spouse if the decedent dies without a will. So a surviving domestic partner would have the same priority to serve as personal representative, the same right to inherit, and the same right to be exempt from Maryland's inheritance tax as a surviving spouse. It's important to note that the partners would have to take the affirmative step of registering as partners prior to either of their deaths for these benefits to be granted. They would need to jointly file a notarized application signed under the penalties of perjury during their lifetimes in order to be considered domestic partners. This would allow an affordable and cost-effective method for partners to get some basic protections in lieu of more robust and more extensive estate planning, which frankly, a lot of Marylanders can't afford. So along with my colleagues, ask for a favorable report. Thank you.
Excellent. Thank you very much. Questions from the committee? Seeing none, thank you very much, Senator. With that, that'll end the hearing for Senate Bill 792. All right, excellent. Then we'll now go on to Senator Carter with Senate Bill 851.
Good afternoon, committee, Mr. Chairman. This bill is a bill that has a long history. It's a seemingly simple bill, but it became a little bit more complex for reasons I'm about to explain. So, Senator West, it was sponsored and brought to me by your good friend in the House of Delegates, Delegate Hill. And it initially, it changes the power of attorney. The purpose of the bill is to ensure that persons that are unable to fill out forms to receive government benefits are able to have an agent, a power of attorney to help assist them with that. And so it was a very simple bill. It passed the House last year. The delegate thought that having a Senate crossfile might help ensure it might pass both houses this year. The bill came out of the former Attorney General's 2020 COVID task force, Access to Justice, and that's where it started. Since that time, the Estate and Trust section of the Maryland State Bar Association formed a task force. And minutes before this bill hearing, I was handed a long redrafted bill that became very complex. And so I can no longer tell you that all this bill does is just change the short form to allow for someone to have an agent. The new bill, my understanding is that it puts protections in to really guard against fraud and does a myriad of other things. I just got off of the phone with the head of the task force, Ryan Wilson. And my ask of this committee is that you bear with me. I can present the bill as it is, and I can send out a copy of the reprint that I just received. But I'm going to ask, and I've already asked the chairman, if we could possibly hold a few moments open next week in bill hearings to have the task force chair present all of the specific changes to the bill, because I think that would be much more helpful. I do think it's a good step that we need in Maryland to help ensure that vulnerable people and people that have no ability to fill out forms to receive benefits do it, and that they're protected, that they aren't defrauded in that process. That's the real goal of the bill.
Excellent. All right, that's it. That's great. Yeah, Ryan Wilson's awesome guy. Not, I'm just saying that because he's a constituent, but he's a really good guy.
He also used to work for DLS.
That's right. That's right.
Thank you.
He's a good man. All right. Thank you very much. With that, that'll conclude the hearing for Senate Bill. No, he's not. No, Senate Bill 851, Senator Carter. We'll now move on to Senator Heddleman, who I see is here. Senator Heddleman with Senate Bill 797. Welcome.
Is it okay if I bring up? Thank you very much, Mr. Chairman, Mr. Vice Chair, members of the Judicial Proceedings Committee. I'm Shelley Heddleman, District 11 Senator, and I'm really happy to be here today with friends and colleagues to talk about Senate Bill 797, which would create a task force on preventing and countering elder abuse. This really goes back to a couple of years ago, and I was at a conference actually in Columbia, Maryland, talking about some of these issues with, I think, each of you, talking about the growing disturbing issue of the abuse of older adults. As we all know, we are an aging and graying community here in Maryland and across the United States. And this is becoming more and more of an issue. And I was sitting in a room with people from the state's attorney's office, people from the attorney general's office, service providers, ombudsman, Department of Aging folks, all different kinds of folks who provide a lot of very important services, direct services and law enforcement around the issue of elder abuse. And I realized at that moment that there were a lot of people and very well-intentioned and committed people who were dealing with this issue in very siloed ways. And this bill is really an effort to have a holistic look at the issue of elder abuse and look at the laws that we have on the books and to determine whether they are sufficient to address this growing and important issue. We have had wonderful conversations with our new Secretary of the Department of Aging. They are tasked with staffing this group. They are very supportive, and I hope that you have a letter from them. And we have a really diverse group of people that we want to make up this task force. It is very time limited and very focused. And I'm going to turn it over now to my panel to talk about more in depth their experience with the issue and hands-on experience and why this important task force and research that will look at what proposed changes we need to make in our current laws and how the issue is evolving and developing and why it's important to do it now. It's pretty well defined. It is time limited and targeted. So without further ado, I will turn it over to Jackie Schroeder. Thank you.
Good afternoon, Mr. Chairman and committee members. My name is Jackie Schroeder. I'm the director of the Elder Abuse Awareness Program at HANA. the Abuse and Trauma Agency of the Associated Jewish Federation of Baltimore. Since launching our program in 2013, we've been providing comprehensive response, including legal, clinical, and shelter services, and prevention education, advocacy, and consultation to victims, families, and professionals. To date, we've served approximately 900 community dwelling victims in Baltimore and other jurisdictions who were being financially, physically, sexually, and emotionally abused and human trafficked. The vast majority of our clients did not meet the definition of Maryland's Criminal Law Code, Section 3-604 and 605, abuse or neglect of a vulnerable adult, nor did they meet the criteria for investigation by Adult Protective Services. Both the laws and investigative criteria are defined in very limited ways related to a victim's lack of competence and capacity. Most of our clients have had the competence to meet their own daily needs and have had the capacity to make their own decisions. Whenever a crime is committed against an older adult, elder abuse should be considered. Therefore, now in Baltimore City, over 5,500 police personnel have been trained about elder abuse. And to further everyone's understanding, we co-authored with the Circuit Court for Baltimore City the Maryland Elder Abuse Judges Bench Card, which now is located in the Judiciary's digital library. In 7 years, almost a quarter of our population in Maryland will be older adults. There's an urgent need now for all our laws related to older adults to be reviewed through an elder abuse lens to enable looking beyond what appears on the surface to ensure victim safety is enhanced and abusers are held accountable. Multidisciplinary agency coordination and collaboration is vital to look at all these facets of elder abuse and the law. And we urge you to vote for Senate Bill 797. Thank you very much.
Excellent. Thank you.
Good afternoon, Chair Smith and members of the committee. I'm Sarah Mirsky-Mickey. I'm the Deputy Director of the Baltimore Jewish Council, which represents the Associated Jewish Community Federation of Baltimore and all of its agencies. I think Jackie said it best. I'm here today in support of the bill, and we have a couple of virtual witnesses as well, but I'm here to answer any questions. Thank you.
We'll pipe in the virtual guests.
Lens to enable looking beyond what appears on the surface to ensure victim safety is enhanced.
Ms. Rodriguez, if you could close the YouTube stream, the tab, or mute it. Ms. Rodriguez, you're up. We can see you.
Oh, I'm so sorry. I couldn't hear anything for a while.
Oh, no worries. If just to make sure that your YouTube stream is closed down or muted, if you could.
Yes, I turned it off.
Excellent. Thank you. You're
All
up.
right.
Good to see you.
Good to see you too. Mr. Chairman, members of the committee, I'm Amanda Rodriguez. I'm the co-chair of the Legislative Committee of the Maryland Human Trafficking Task Force. I am just here on SB 797 to thank the senator for putting this bill forward and for including the Maryland Human Trafficking Task Force on the committee. We are happy to be involved in that way and support this bill as per favorable report. Thank you.
Excellent. Thank you very much. All right. Is Ali Andreessen still in the Zoom room? Okay. All right, then with that, we'll go to Shirley. All right, there you go. Ms. Andreessen, you're up. Welcome.
Good afternoon. Thank you so much for the opportunity to testify in support of Senate Bill 797. My name is Ali Andreessen, and I am the Long-Term Care Assistance Project Staff Attorney at Maryland Legal Aid. Legal Aid is a nonprofit law firm with 12 offices across Maryland that provides free legal services to the state's low-income and vulnerable residents, many of whom are older adults. As noted in our written testimony, the importance of this bill cannot be overstated. This bill creates a task force to study existing Maryland law, policies, and practices relating to elder abuse and other crimes commonly committed against vulnerable older adults. This bill proposes an interdisciplinary approach, bringing stakeholders together from across industries and across the state to study and recommend a comprehensive, inclusive approach to protecting Maryland's older adults. It is vital for Maryland agencies and organizations familiar with elder abuse to have the opportunity to coordinate and figure out what is needed for Maryland's older adults to age safely and with dignity. Legal aid has extensive experience working with older adults who have experienced abuse. The most common situation historically is a family member named as a power of attorney abusing the older adult emotionally, financially, physically, or some combination of the above. Allegations of any type of abuse are heartbreaking, whether from an unrelated caretaker or a family member, whether in an institutional setting like a nursing home or in the privacy of their own home. You never get used to it. Our advocates work with the older adults to ensure their immediate safety, counsel them on their rights, support them by working with our partner organizations and government agencies, and advocate for them in the process of achieving their goals. The task force can address potential shortcomings, loopholes, and other issues within the current framework that allows the abuse to our vulnerable population to persist. For the reasons stated above, Maryland Legal Aid strongly supports Senate Bill 797 and urges a favorable report. Thank you so much for the opportunity to speak on this important bill.
Thank you very much, Ms. Andreessen. Ms. Lombardi, you're up next. Actually, yeah, go ahead.
Great, thank you. Thank you, Chairman, members of the committee. My name is Joyce Lombardi. I would love to be there in person, but unfortunately, I am quarantining. I represent Center for Hope, which provides crisis intervention and prevention services to the Baltimore region. As many of you know, we run one of Maryland's largest and oldest child advocacy centers. We also have an elder justice program that applies the advocacy center model to elder abuse. You have our testimony. We wholeheartedly support this bill. We have a few friendly amendments, and you'll see in our written testimony, we would love to add a member of the Maryland Children's Alliance for 3 reasons. One, because adding the advocacy center model brings about 40 years nationally recognized best practice of collaborating the experts, as Senator Hedelman mentioned, and exactly as the task force is doing. Multidisciplinary team, forensic interviewer, mental health, medical, law enforcement, social services, to the forensic interview. It is the gold standard, certainly in witness interviews, not just for victims, but also for courts, preserves evidence, prevents trauma. The leading edge of forensic interviews is understanding, just as you wouldn't ask a 2-year-old a question the same way you would ask a 16-year-old, nor would you ask a 55-year-old a question about their abuse the same way that you would ask an 85-year-old or somebody with Alzheimer's or dementia. Third, a lot of the advocacy centers model that is in Maryland right now already deals with vulnerable adults, and so there is some overlap. We again thank the bill sponsor and the advocates, wholeheartedly support, and we urge a favorable report. Thank you.
Thank you very much, Ms. Lombardi. We'll now move on to Mr. Shirley. You're up.
Yes, sir. Good afternoon, Mr. Chairman and distinguished members of the committee. My name is Zach Shirley. I'm the director of the Maryland Medicaid Fraud Control Unit in the Office of the Attorney General. Since its inception in 1979, the Medicaid Fraud Control Unit has been charged with investigating and prosecuting the abuse, neglect, and exploitation of vulnerable adults in this state. At present, our unit's attorneys have a combined 45 years of criminal prosecution experience working with vulnerable adults. The abuse and neglect and exploitation of the elderly population in Maryland is an emotive, if disturbing, topic. The stories of these victims cry out for justice, and that justice is what this office seeks to provide. Over the years, however, our office has seen examples of cruel, callous, and exploitive conduct for which the law did not provide appropriate or sufficient tools to appropriately address the harm. Overly vague or overly specific definitions, blind spots in the law for new or emerging types of abuse, or rules that prejudice the ability of the elderly to seek recourse because of the natural consequences of aging, such as fading memories and failing health, must be addressed. Our office has noted these issues and we have sought solutions, and we would welcome the opportunity to be included in the proposed task force, because we know that while prosecution of those responsible for the abuse, neglect, and exploitation of vulnerable adults is part of the solution, it is one that it must be multidisciplinary and address the root causes of abuse in order to create a system that not only punishes abuse, but prevents it in the future. Senate Bill 797 is an exciting opportunity to formalize the conversations that already take place in multiple stakeholder forums, task forces, and community group meetings, and to then formalize those results as a concrete recommendation for change. And as such, we urge a favorable report. Thank you.
Excellent. Thank you all very much. We have a question from Senator Sidnor. I know Mr. N's going to come up. Actually, come on, Mr. N, you want to come up and testify, and then Senator Sidnor will have you. But if the virtual participants could stick around, we've got one question. Thank you.
Thank you very much, Mr. Chairman. Robert Anton, appearing before you today on behalf of the Maryland Bankers Association. Maryland Bankers Association is very, very much supportive of this legislation. I've signed up favorable with amendments because we would like to see a banker added to this task force. Financial, you heard the witness testify that a big part of elder abuse is financial abuse. There have been bills for, I don't know, the last 4, 5, 6 years to deal with that issue. We've always worked with the Office on Aging, the Consumer Protection Division on those bills. And we just think it'd be a good idea to have somebody on the task force from the banking industry that can also has expertise in dealing with the issues that elders face financially. So that would be the nature of our amendment. I didn't have a chance to meet with the sponsor, but I chatted with her on her way out the door and she seemed amenable to the amendment. Thank you.
All right. Thank you very much, Mr. Enton. Senator Sidnor has got a question.
Thank you. And said the sponsor, she's not here. Okay. All right. When I was looking at the bill, I thought I was going to see the usual participants, but I didn't see the Maryland States Attorneys Association. So I was curious, and this question is directed to the gentleman from the Attorney General's office. Do you all generally, are you all the ones who generally prosecute these types of crimes rather than our state's attorney's offices?
The answer to that is yes. We try to bring those cases to us. We reach out to the different state's attorney's offices to network with them and let them know we're here as a resource. But it is entirely possible for these cases to be addressed by the state's attorney's office. I know Montgomery County has their own sort of special victims unit, so we don't see a lot of cases from there because they handle their own. So I don't know that the answer is yes, because we don't handle them all, but we do try to be a resource and to handle as many as we can.
Thank you. And for the witness that spoke about human trafficking, I'm trying to get my mind wrapped. What's the connect between human trafficking and elder abuse? I mean, what could you mind explaining?
Sure. It's actually kind of an emerging trend in the anti-trafficking world of connecting elder abuse, especially that when we're talking about folks going into nursing homes and then dollars being attached to their stay within those nursing homes and the person then being moved from placement to placement to placement. So it is by all like definitions of human trafficking because they are quite literally moving that person and then exploiting them for financial gain. So it is definitely attenuated from what you normally hear me talking about in terms of like child sex trafficking when we have a sex act happening. This is more attuned to labor trafficking, right? Because that body is essentially being used for the purpose of exploiting that individual so that they can have financial gain, the traffickers themselves.
Thank you. And the last question, if anyone can speak to, sure.
I want to say that local state's attorney's offices are prosecuting economic crimes against older adults and also are dealing with physical abuse situations. Where trafficking is concerned, what we're seeing is older adults are being trafficked for their benefits, their Social Security, VA benefits, food stamps, pensions, and also they're being trafficked for labor, for sex, and for body organs. And we're seeing that happening not only in facilities, but also in community dwelling older adults by family members.
And the last question, if anyone can answer this, because again, I'm trying to understand. Usually it jumps out at you why certain seats are made for certain organizations or entities. I'm trying to understand the Baltimore City Fire Department. Why are they included?
Yeah, because if a police officer knocks on a door of, let's say, an unlicensed facility, the person who's there doesn't have any obligation to answer that door, nor do they have to answer the door to an adult protective services worker. But they do have to answer the door to a fire marshal, a representative. And in fact, the fire marshal's office holds a lot of power in that instance. And they're really a boots on the ground, frontline protector of older adults who are being moved into these unlicensed homes.
And this task force is supposed to be statewide though, right?
Yes.
And I mean, I look at it and I wonder, instead of being so specific and saying chief of Baltimore City, if you might look at a fire department organization or association that kind of acts as an umbrella group for all fire departments, because different fire departments might have different procedures and things. That was the reason for that question. So look, thank you very much.
Senator Sinner, there also is a amendment in there from Senator Hedelman to add Maryland State Police as well. So I think there's two different entities to add. And I know there are a lot of favorable with amendments with other groups. We didn't know how many people were so excited, but we also didn't want this task force to be, 50 different organizations. We actually wanted to be really effective. And sometimes when you have so many organizations, it's just harder to get work done. But also what Jackie didn't talk about is that there's been a federal grant for a while to coordinate within Baltimore around elder abuse. So part of the reason there are a few more Baltimore-based organizations is because they've been doing this work in a local level. So they kind of already have that coordinated expertise. But there is, a request to have someone from a more rural area, which we would love to also bring in. We have folks from Montgomery County who have been doing similar work as well. But that was kind of the reasoning behind having a slightly more Baltimore centric. It's because a lot of this group of people have been working together on this issue in the local level and want to do it at the state level.
Thank you very much.
So thank you very much, Senator Sidnor. All right, seeing no further questions from the committee, thank you all very much. All right. Excellent. With that, that'll end the hearing for Senate Bill 797. We'll now move on to Senator Sidnor with Senate Bill 478. Senator Sidnor, you're up.
All right, good afternoon, committee. Senate Bill 478, Charles Sidnor for the record. This is a very simple bill. Back in 2019, we here in the General Assembly, we created the Maryland Lynching Truth and Reconciliation Commission. This commission has been going about doing its work, but it still needs a little bit more time to finish its mission. So what the bill does is it extends the commission for another 2 years. With that, I ask for a favorable report. That's very simple. Jill? Thank you, Madam Chair.
Thank you very much. Next bill? No, because it's bills. Okay. Senate Bill 686, presented by Chairman Smith.
Thank you, Madam Chair. I'm going to bring up just a small panel first, and then we'll start off. So, Madam Chair, members of the committee, Senator Smith here to present Senate Bill 686. Before we start today, I do want to just acknowledge and thank Delegate C.T. Wilson, who has been the champion behind this issue, the driving force behind this issue in the Maryland General Assembly. Also want to thank him for his courage and his tenacity on this issue. Claudia Remington from Maryland Essentials for Childhood, Kathleen Hoke, professor of law, University of Maryland Carey Law School, Catherine Robb from Child US Advocacy, and even the folks that have voiced concern for this bill and who have come to the table with ideas to act in earnest to try to resolve the issue before us. And then finally, and most importantly, the countless survivors and advocates that have stood strong and steady throughout the years and who've come down to Annapolis year after year after year to get this right. Now, the goal of this legislation is relatively simple. It's access to civil justice for survivors of child sex abuse. However, the manner in which we get there, as I've described to many members of this committee, is anything but simple. I've said that I've likened it to three-dimensional chess. It's really like six-dimensional chess, and I'll lay that out. You've got to consider things like, what is the statute of repose? What is the statute of limitations? How are they different? Does it matter? What are the constitutional issues that arise when repealing the statute of repose or limitations? What are the ramifications for state and local government to include school boards? How does insurance work? How long are the insurance tails? Does an infinite look back mean back to the founding of the nation? How long is that really? What happens when I acquire a business that now has a claim which has been revived from several decades ago? These are just a few of the top line major issues that arise when facing this issue. So I say all this because we need to be mindful of the consequences, both the intended and the unintended, of passing legislation of this magnitude. But we also need to be mindful of the consequences of inaction and injustice. So today I'm going to provide you with the legislative history associated with this bill. I'll walk through the mechanics of the bill, and then I'll highlight again some of those major issues that arise with this legislation. Now, to the legislative history, the law before 2003, October 1st, 2003, was that these cases would have been subject generally to the rules of the statute of limitations, which provide that civil action must be filed within 3 years from the date that it accrues, unless there's some other statutory provision that provides for more time. Now, if that cause of action was a child sex abuse case and that accrued to a minor, this general 3-year statute of limitations would be told until the child reached the age of majority, which means 18. So upon being an adult at 18, they would have the ability to bring forth suit until they were 21. And that's before October 1st, 2003. After this body dealt with that issue in 2003, we passed Chapter 360, which provided that an action for damages arising out of the alleged incident of sexual abuse that accrued while the victim was a minor had to be filed within 7 years of the age of majority. And at the time, that law was not to be construed to apply retroactively to revive any action that was barred by application of the applicable statute of limitations before October 1st, 2003. Fast forward to 2017, which is really what we're facing before us today. In 2017, we passed chapters 12 and 656. Now, under these acts, an action for damages arising out of an alleged incident or incidents of sexual abuse that occurred while the victim was a minor first had to be filed at any time before the victim reached the age of majority, or it must be filed within the later of 20 years after the date on which the victim reached the age of majority, or 3 years after the date that the defendant was convicted of a crime relating to that alleged incident. So basically, until you were 38, or 3 years after the perpetrator was convicted of that crime. Now, here's where it gets interesting. There's a piece of the bill that included a statute of repose or statute of limitations, and that's up for debate, which prohibits a person from filing an action for damages arising out of an alleged incident or incidents of sexual abuse that occurred while the victim was a minor. And again, the general 20 years plus 3 years after conviction still applies. So what does this bill do? The bill is actually pretty straightforward. It provides for a definition of sex abuse, which actually, after revisiting it, it's found on page 2. You'll remember that we passed a bill off of the floor, past third reader last week, that the language for perverted sex act, we actually repealed that. So we're going to have an amendment to address that, because that's still, that language is actually still in this version of the bill. So we'll have to amend that, assuming that that bill passes the House of Delegates, which it has for the last 5 years or so. It creates a look back window So notwithstanding any time limitation under the statute of repose, the statute of limitation, the Maryland Tort Claims Act, or the Local Tort Claims Act, or any other law, basically meaning that an action for damages arising out of the alleged incident or incidents of sex abuse that occurred rather, while the victim was a minor can be filed at any time. It's a look back. Under this version of the bill, no limitations. Awards for private and nonprofit entities, the total amount that may be awarded to a single claimant against a single defendant for injuries arising from a single incident or occurrence may not exceed $1.5 million. For a governmental entity, so state, local tort claims act, state and local tort claims act plus school boards. So we're talking about the total amount that may be awarded to a single claimant against a single defendant from the injuries arising out of a single incident or occurrence may not exceed $850,000. So to summarize, the bill would eliminate the statute of limitations or repose for child sex abuse. It would create a permanent window for older victims. It would allow both public and private entities to be sued. It would eliminate the notice of claims deadlines for public entities in child sex abuse cases. And it caps liability for the public entities at $850,000 and for private entities at $1.5 million. So now onto the complexities of the bill surrounding and the other issues surrounding the ancillary issues surrounding the bill. Now, the first issue which arose during our briefing earlier on the session was whether this was a statute of limitations or statute of repose and whether it mattered. So I'm going to crib from, we cited two letters from the Attorney General, or two series of letters from the Attorney General. One series of letters started in 2017 all the way up to 2022, which gave us advice as to how to proceed. In that briefing, I asked a question about the statute of repose or limitations look back for statute of repose for asbestos. That prompted Professor Hoke here to do some fantastic research. And in that research, she found a letter from the Attorney General that was spot on to the issue as to whether a statute of repose, whether you could do a look back. And in that case, it was 2 years, right? 2 years in that point. But the general principle applies. And so I asked the Attorney General can you just sync up what was said in that initial letter that was handed down in 1990, Vice, what you've been giving us advice through basically the last 5 years from the passage of this 2017 bill. And so actually I received that letter yesterday, and it'll be entered into the record on your laptops, and I will make sure that you all get hard copies and soft copies of that letter as well. But I'm going to start to read a little bit from that letter because I think it's extremely important to have entered into the legislative record. She starts the analysis, or the Attorney General rather starts the analysis by saying, look, the first issue is whether allowing a victim of child sex abuse to file a civil action for sexual abuse at any time without limitation and without regard to previous time limitations, including any previously barred action, impairs a vested right. Remember, that was basically the crux. It was the lion's share of the debate or of the presentation during our briefing earlier on in the session. In evaluating that question, we must consider whether we extend the statute of limitations for such a claim, or alternatively enacted statute of repose, and whether we did that in 2017. So what is the statute of limitations and what is the statute of repose? I'm going to crib from that letter because I think it's a pretty succinct definition, and then we're going to go on to whether it matters. What is the statute of limitations? Now, this is a direct excerpt from the letter. The state's highest court has explained that a statute of limitations is a statute establishing a time limit for suing in a civil case based on the date when the claim accrued. And then statutes of limitations are not substantive and can be told for reasons such as fraudulent concealment. She goes on, or he goes on. So then what is a statute of repose? A statute of repose is a statute barring any suit that is brought after a specified time since the defendant acted, such as by designing or manufacturing a product, even if this period ends before the plaintiff has suffered a resulting injury. Now, she goes on and says, I say she and he goes on and says, the purpose of the statute of repose is to provide an absolute bar to an action or to provide a grant of immunity to a class of potential defendants after a designated time period. And she notes that the that the statute of repose is a substantive grant of immunity derived from a legislative balance of economic considerations affecting the general public and the respective rights of potential plaintiffs and defendants. It's a lot. So the next question is, if you understand the difference between, which it's clear as mud here, but if you understand the difference between a statute of limitations and a statute of repose, the next question is, does it really matter in this instance, or how is it to be applied to this set of facts in this bill? So we can argue whether it is, or whether we created a statute of limitations or a statute of repose in 2017. I know a number of, I voted on that legislation. I was admittedly not aware of what a statute of repose was. And when we did the research, Professor Hoke did the research and we had counsel do the research, we found only one statute of repose in our code book, which dealt with areas in construction law. So the answer that I've deduced from this letter is that it is clear that it is not clear. So I'll read more from the Attorney General's letter. Even if the 2017 enactment was intended to create a statute of repose, an elimination of the statute of repose may not impair a vested right in all cases. Again, more clear that it's not clear. In 1991, the General Assembly enacted the Courts and Judicial Proceedings Article 5-108, which is clearly a statute of repose, to add exceptions for asbestos claims, which is that 1990 letter that I spoke to before. Was a letter of advice to the General Assembly. And that stated that we have previously advised that the statute of repose may be altered retroactively without violating due process. The letter noted that Maryland's highest court would analyze whether the retroactive application would divest or adversely affect vested rights. And that letter is also, I believe Professor Hoke provided that letter in her testimony, and that should be available to you on your laptops. Now, because the Maryland case law on vested rights was scant at the time, the letter goes on, it cites from cases from other jurisdictions that looked at, among other things, the public interest served by the statute. The letter then concluded that the Judicial Proceedings article created no vested rights and that asbestos carve-outs are still good law today. So those carve-outs are still good law today for that statute of repose. The letter goes on. In the last 23 years, since that first initial letter in 1990 was written, Maryland case law on vested rights has developed. A retrospective application of a limitations period may impair vested rights in some circumstances. The Maryland Supreme Court has pointed out that it consistently held that the Maryland Constitution ordinarily precludes the legislature from, one, retroactively abolishing an accrued cause of action, thereby depriving the plaintiff of a vested right. Number two, from retroactively creating a cause of action or revising a barred cause of action, thereby violating the vested rights of the defendant. And it cites the Dua case and the Muskin cases. Now, those two cases, however, did not involve the revival of a cause of action. And the courts in other states have upheld retroactive extensions of statute of limitations for child sex abuse, largely relying on the compelling public interest. So, and these are the two most stirring sentences from that letter. Consequently, while it is possible that Senate Bill 686 retrospective reach to time-barred actions would be found to be unconstitutional, it is not a given outcome. It is an open question. And in summary, it is our view that Senate Bill 686 is not clearly unconstitutional. And if the General Assembly chooses to provide victims of child sex abuse an expanded chance for justice, I can, in good faith, defend the legislation should it be challenged in court. So with that, going back to the alternate and the ancillary considerations of what are the ramifications for state and local government? How does insurance work? Does an infinite look back go all the way back to the founding of our nation? What happens when I acquire a business? All these issues have been actually addressed through various pieces of testimony that have been submitted, and I suspect that my guests or my panelists will address. But all this to say is that we've been given some guidance here that it is an open question, and we will make that case in court if this bill does get challenged. So then the next question is, what do you want to do? Do you want to afford survivors an opportunity to seek access to civil justice? Or do you want to foreclose that window to what we did in 2017? I believe it's within the interest of justice that we provide this opportunity for survivors of child sex abuse. And with that, I ask this committee for a favorable report. I'll stand up here with my panelists. After they present it, I'll stand for questions. So with that, I'll turn it over to Professor Hoke.
Thank you.
Thanks.
Mr. Vice Chair, members of the committee, I'm Kathy Hoke, a professor at the University of Maryland, Carey School of Law, here today to help answer those questions about whether Court's 5-117 is a statute of repose or a statute of limitations, whether that matters. And more importantly, whether you can pass Senate Bill 686 confident that you're not taking an unconstitutional action here. On the statute of repose issue, it is unclear. I think the better answer is this is not a statute of repose because there is the hallmark of a statute of repose missing here. A statute of repose, the period of limitations begins not at the time of injury, but at some other trigger of time, such that a claim that has not yet accrued is extinguished with the passage of time. So it works in the construction context. You put that building available. After 10 years, the architect has no liability, whether there's been injury or not. 5-117 lacks that hallmark of a statute of repose. You know, you can call something a duck, but if it doesn't quack and waddle, it's not a duck. And I don't think 5-117 is a statute of repose. Doesn't matter. Let's look at the constitutional analysis, whether this is a statute of repose or a statute of limitations, and say, can this body repeal with retroactive application that statute? And the answer here is maybe, right? It is just what I said to you on January 19th. What I said 2 years in a row in the House is that it's unclear. That's what the Attorney General has told you, but you have your practice. In 1991, this body repealed a part of Section 5-108, our known statute of repose in Maryland, with retroactive application on the Attorney General's advice that that was constitutional. Nothing has changed in Maryland law to change that outcome. As conscientious legislators, I appreciate you want to know the answer to that question on constitutionality, and I encourage you to pass this bill knowing you have done your work in that regard. Thank you so much. I encourage a favorable report on Senate Bill 686.
Thank you, Chairman. Thank you, members. My name is Catherine Robb. I'm the Executive Director of Child U.S. Advocacy, and I work on this legislation all over the country, including in Congress. The data tells us right now that 1 in 5 girls and 1 in 13 boys will be sexually assaulted before their 18th birthday. We are clearly living in an epidemic. We also know that 90% of the victims know who their perpetrators are. And because of this and the science of traumatology, what we're finding across the country and in Congress is that legislative bodies such as yours are understanding this terrible epidemic and making changes accordingly. These are not typical torts. Let's be clear. We're talking about the rape, sodomy, and sexual assault of our children. Because of this, 27 jurisdictions have revived their past revival legislation, 24 states and 3 U.S. territories in total. We also have 18 jurisdictions, 15 states, 2 territories, and the federal government, that would be Senator Durbin's bill, that have eliminated the statute of limitations. Congress is also making other changes. There are bills right now that are trying to incentivize this body like this to make these changes. And this year alone, 30 states have introduced SOL reform legislation. 23 are eliminations, 18 are revivals or windows, and 10 are permanent windows. 0 states have passed a cap on damages. So this part would be a little unusual compared to the rest of the country. You will hear the sky is falling types of exaggerations and scare tactics. But I think what we really need to be fearful of is that our children are in great danger and the state needs to act. I thank you for your time.
Vice Chair, and distinguished members of the committee. My name is Claudia Remington. For close to 20 years, I served as the chair and then executive director of the State Council on Child Abuse and Neglect. I strongly support SB 686. As a lawyer, I am fascinated by and get lost in the complex constitutional issues the bill presents. Fortunately, as Senator Smith just informed you, the Attorney General is clear that there is no case on point, and he is prepared to defend the Child Victims Act should it be challenged in court. Perhaps that will allow us to focus on what this bill is really about. First, providing an opportunity for survivors to seek justice and healing by proving their cases in a court of law. And equally important, ensuring our children are safe and we prevent child sexual abuse before it happens. Child sexual abuse is a preventable public health problem. As Dr. Letourneau indicates in her written testimony, 1 in 5 girls and 1 in 13 boys is sexually abused before their 18th birthday. 11.1% of the participants in the Maryland Behavioral Risk Factor Survey indicated that they were sexually abused as minors. Currently in Maryland, survivors and taxpayers bear the burden of those costs. The Child Victims Act will shift those costs to the perpetrator and those who protect them. Eliminating the statute of limitations and providing a look-back window exposes hidden predators who are still in the community working with children. During a 2-year look-back window in California, litigation exposed more than 300 predators who were still working with children. Preventing child sexual abuse requires a comprehensive approach, including strong state policy. Adding the protections of the Child Victims Act to the Sesame and Prevention Education bills the General Assembly passed in the last 5 years will ensure that Maryland has some of the strongest laws in the country aimed at preventing child sexual abuse. Together, these policies protect children by sending a clear message to perpetrators and those who protect them that Maryland is not open for their type of business. There can be no justice for survivors and no preventing child sexual abuse without holding perpetrators and those responsible for protecting them accountable. For these reasons and others in my written testimony, I ask for a favorable report. Thank you.
Good afternoon, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We are here in strong support of Senate Bill 686. As you've already heard, this is a survivor-oriented approach to help survivors of sexual abuse. The Maryland Coalition Against Sexual Assault has supported expanding the statute of limitations for years. I was here in 2003. We continue to support this expansion and the survivors advocating for it. Rather than repeat the testimony you've heard, I do want to ask the committee to consider this. These efforts to expand the statute of limitations have dragged on for decades. At this point, the reality is that there are many cases that theoretically are going to fall into this 2-year look back, but no tort attorney is going to take this case. Perpetrators and collaborators have died, businesses, schools, churches have closed, memories have faded, the likelihood of winning a lawsuit is small. And there are still also some real concerns about the constitutionality of reviving claims. I'm really very glad to hear the Attorney General's opinion, but certainly any ethical attorney would also advise a client about the risks. And some survivors might not want to endure the risks of and the rigors of litigation, given the constitutional concerns. So given all of this, MCASA asks you to think about the survivors whose abuse falls in that look back window, but are not going to have meaningful access to the tort suits. Consider creating a fund to provide survivors with reimbursement for healing activities. Perhaps consider authorizing the state, perhaps even the Attorney General, to file suit for survivors when potential recovery is too low, to interest the private bar, or perhaps they'd prefer the Attorney General or someone like that to private representation. I again want to say that MCASA fully supports the choices that adult survivors of child sex abuse make to pursue a civil lawsuit if this bill is enacted. We also support the many survivors who will not benefit from private lawsuits, and we urge this committee to also take steps to support them. We urge a favorable report on Senate Bill 686.
Thank you, Ms. Jordan. Questions for this panel or the sponsor? Let's go with Senator Sidnor first, please.
Thank you very much. I have been inundated with a variety of emails from constituents who have said they're in some way affiliated with the Archdiocese. and I believe there must be a form letter that they're sending out, but the point that they, each of these letters is continuing to raise is that private entities are being treated differently than public entities. So I was hoping you all might be able to speak to the question of why I think it was 1.5 million for private entities and 850 for public.
Yes, so first, I just want to point out. Oh, sorry. Thank you. First, that the cap for private entities only applies to claims that are revived under the legislation. The caps that will exist for public entities is both retroactive and prospective, and reflects that we do have both the Local Tort Claims Act and the State Tort Claims Act, which already set limits on tort claims against the state, as well as provisions relating to claims against local boards of education. And so consistent with existing law, we have just increased the amount of damages that are available against public entities from what is already in those state provisions. So there's only the cap retrospectively of 1.5 million for private entities. Why the difference? The question really should be, why wouldn't there be a difference? In every type of case that you litigate against the state of Maryland or against one of our counties, municipalities, or a board of education, you are subject to the restraints of the Local Government Tort Claims Act, the State Tort Claims Act, and the provisions related to boards of education. Why in this case would we change that and allow those caps to apply to private claims? We're talking about claims that are extraordinary here. These are the worst types of actions that can happen. And so this public-private disparity is something that exists as part of our law because sovereign immunity is a principle that protects the state coffers. Moreover, the state and local governments are already paying some of the expenses associated with the harm that has occurred. We provide support, public benefits, and the like to these survivors of child sexual assault. And so the state and local governments are already, and the education system helping children who are managing the trauma from their sexual assault. So there's already a burden on the governmental entities. And again, I ask, why would you make it different for this type of case when in every other case there is this difference between public and private entities?
Thank you. And one other question. On page 3, line 26, the bill talks about a single incident or occurrence. And I'm wondering what your intent might be with that. If we're talking someone who's been sexually assaulted by one individual over the course of time, would that be considered multiple incidents or that a single incident?
So again, that language is drawn from existing statutes that pertain to liability for single occurrence, single incident from the state and local government tort claims acts. We didn't make up that language, and it really is for a court to determine. It's a fact-specific analysis for a court to determine whether an incident is, separate days or incidents that occurred months apart or, incidents that occurred in one day. So I know it's tough because you want to have a discrete answer to that question. We've struggled talking with Chairman Smith about what it means, but that's the language that we already have and that courts are already using in context. And so it makes sense to continue with that language.
So what does case law say that it means?
The case law is really on a fact by fact, scenario. We don't have a tremendous amount, we don't have much at all in the appellate court decisions. And so it is trial courts that are determining, right, whether something that occurred on day one, where there was perhaps, a child sexual assault that occurred on a field trip with a child. And then a month later, that same perpetrator, victimized that child again in the, vestibule of the church. And so whether that's 2 incidences or 1 is really a fact-specific question for the courts.
What do you think it means?
I don't think my opinion really matters. I'm not a judge. I'm not a jury. And again, because it's a fact.
I'm just trying to understand the intent, because once we do this, I mean, we want to make certain that we're passing legislation with the intent of the sponsors in the panel, so that's why I'm asking the question.
Fair question, but again, it is such a fact-specific analysis. The question here is, was the negligent supervision, something that was occurring over time? And so the cause of action for negligently supervising that individual should be one occurrence. But if it occurs, what if it occurs again in one instance, and then 2 years later, that same individual who was moved to a different parish, who was, or moved to a different troop or to a different school, is continuing that same conduct? And there's again, that same lack of supervision, that lack of protection of the child. I dare say, I think in that instance, that's more than one instance. That's more than one occurrence.
Oh, we've also had this discussion when it comes to things like theft and so I was just curious what your opinion was. Thank you very much.
Thank you, Mr. Chair. First of all, Ms. Jordan, could I ask you a question? I had never heard of the idea of a fund before. Could you give us more ideas of how such a fund might be set up and how people would make claims against the fund? Where would it be funded, et cetera?
Yes, thank you for that question, Senator West. It really is inspired by the work of the Attorney General this year and his anti-discrimination bill. If you look at that, that's the same sort of setup where he's bringing suit on behalf of the people for anti-discrimination efforts, and they're creating a fund with the penalties that are generated from those suits. And so I would anticipate that sort of fund would both have penalties from those sorts of suits, and then also I would expect that there'd be some general funds to at least kind of get things rolling. You do have the criminal injuries compensation model already in place. It is very much driven by the criminal justice system. And so many of these cases are really going to fall outside of it. And it's also extraordinarily bureaucratic. And I think that generally speaking, we want to be more supportive of survivors, and a healing therapy might be, some sort of yoga practice or psychiatric treatment or many, many different things.
Well, this seems to me, this is a different approach than we've had suggested to us before, which I think maybe has some merit we should take a look at. It's clear, is it not, that there is no statute of limitations on criminal prosecutions. So that, I think you're nodding your head yes.
For any felony. So there are some misdemeanor child sex abuse cases that perhaps would fall outside of that, but I think generally
most of these cases would be classified as felonies. So at any time, a state's attorney or the Attorney General of Maryland could file a lawsuit. And the Attorney General, as I understand it, has a long list of people that he hasn't made public that he believes committed these sorts of crimes. So at any time, he could file suit against them or the institutions which employed them and failed to properly supervise them, and seek to recover monetary damages that could be put into such a fund, correct?
That would be the concept behind that sort of fund. Yes, I do. It does sound to me like you're mixing the criminal prosecution a little bit with the civil prosecution.
No,
you're going to have
criminal law,
perpetrators.
there are monetary penalties in criminal law. So the Attorney General, if he convicted people or institutions of violating the law, and could get the court to sentence them to monetary penalties, which could be put into the funds, right?
Using a civil theory, yes. I mean, I do think that many of the cases that we're anticipating under this particular piece of legislation are against the kind of collaborators who helped cover up these cases. And in particular, one of the things we're very concerned about are those who really actively conspired to protect perpetrators. And so those in particular, you might want to look at as penalizing in a particular way. I don't see how you would get that group of bad actors under the felony laws. But certainly you could allow them to be sued, have penalties, and have those penalties help survivors, even if the tort suit is very weak.
Okay, well, thank you. That's food for thought. Thank you so much. Could I now ask some questions of the bill's sponsor? Thank you very much.
Yep.
And I will try to not abuse the privilege of asking questions, but I do have a number of questions. So first, to continue the line of discussion that I just had with Ms. Jordan, there's no limitation on criminal prosecutions of the abusers So this bill, is it not, is solely about enabling people who allegedly were abused many decades ago to file lawsuits demanding large monetary damages from alleged abusers or the institutions that employed them.
So that's correct, but although, we talked about the caps that were in place, and that's obviously a novel concept here that I don't think has been employed in any other state. But so up to the limit, yes, up to the 1.5 or 850,000.
Okay.
Just to dovetail on, I wanted to add more context on that too for Senator Sidnor. And we did something similar for police reform a couple of years ago, where we basically essentially doubled the exposure under the Local Tort Claims Act and State Tort Claims Act. So it was that, and that applies both retro and prospective. So, that is something that was never available before, and now it's more money that's available, to the survivors on the public side of the house. So I wanted to make sure that's clear, even though it's a novel concept, it's still something that is a giant leap forward.
Okay, so I'm reading the first substantive section of the bill, which is on page 2, and it says, notwithstanding any time limitation under a statute of limitations, a statute of repose, the Maryland Tort Claims Act, the Local Government Tort Claims Act, or any other law, an action for damages arising out of an alleged incident or incidents of sexual abuse that occurred while the victim was a minor, may be filed at any time. That's what the bill says. So let me call your attention to this decision of the Court of Appeals of Maryland in Dua. And here's the language of what the court said. It said, this court has consistently held that the Maryland Constitution ordinarily precludes the legislature, 1, from retroactively abolishing an accrued cause of action, thereby depriving the plaintiff of a vested right, and 2, from retroactively creating a cause of action or reviving a barred cause of action, thereby violating the vested right of the defendant. So the barred cause of action would be another way of referring to a statute of limitations, I think, and creating a cause of action would be another way of talking about a statute of repose. So that being the language of the Maryland Court of Appeals, can you name for us the decision of the Court of Appeals that overruled Dua and held that it is okay for the legislature to revive a barred cause of action as Senate Bill 686 would do?
Well, the professor will tell you it's dicta, but there is no case. There is no case on point. And that's why, I read those two side by side, those two excerpts from the Attorney General's opinion that came out yesterday, which you don't have. But that's why I said, if you read farther on in his analysis, it says that the Dua in the Muskin cases did not involve the revival of a cause of action. And the courts in other states have upheld retroactive extensions of statutes of limitations for child sex abuse, largely relying on the compelling public interest. And so there is no case on point. But I think the professor would argue that it's dicta, but and so may not be controlling anyway, but in this instance. So, the answer is there's no case on point, but if you read the Attorney General's analysis, I think that's a pretty good rejoinder to what Dua could be used to explain that there's the foreclosure here.
So in past years, when we've been talking about this and when the press has been writing about this, almost entirely the focus has been on the Catholic Church.
That's right.
But is it fair to say that under your bill is not just limited to suits that might be filed against the Catholic Church? Your bill would enable suits to be filed against churches of any denomination, synagogues, the Boy Scouts, the Girl Scouts, private businesses, including dental practices, brokerage firms, large corporations, small corporations, law firms, medical practices, private schools, private hospitals, religious schools, private colleges, any other private institutions in the state of Maryland, as well as any public institutions you could think of, from elementary schools to middle schools to high schools to community colleges to public hospitals to governments who might have harbored a sex predator in the government and who's preying on people employed by the government. That's true, isn't it?
Well, that's 100% accurate, but emphasis added on who may be harboring someone who's committed child sex abuse. But yes, that's absolutely true. And everyone is been consistent with that. I think that's true.
Okay.
No, absent misrepresentations or from the press, everyone here has been consistent that that is the case.
So anyone is fair game. So if someone can allege that 50, 60, 70 years ago, someone in any institution in the state of Maryland abused them sexually, that person, after if this bill's passed, can file a lawsuit in the courts to recover large damages from any institution in the state, not just the Catholic Church.
Subject to the caps, yes.
Yes, okay. Now, I'm looking at some language that you deleted. The current law provides that there must be a finding of gross negligence on the part of the person in order for a judgment to be entered against them. You've deleted the gross negligence standard, haven't you?
I punt you on this one. I'll let the professor answer that one.
Yes, in existing law, if the claim is filed 7 years, after 7 years, then the plaintiff has to prove gross negligence.
Right.
The intention is to remove that additional requirement for later cases.
So you're making it much easier for people to sue someone for something that happened 60 years ago.
Correct.
Okay. In the bill that we had last time I saw it, there was a 2-year window for cases like this to be filed. And you've eliminated the 2-year window so that there's no statute of limitations whatsoever in this bill.
That's accurate.
Someone could be 95 years old and sue an institution for something that happened 85 years ago, and that lawsuit would proceed in court if this bill gets passed.
That's accurate.
Okay. Now, let me go down to paragraph C on page 3 of your bill, which refers to against a single defendant for injuries arising from a single incident or occurrence. So, and then there are these dollar limitations. But let's hypothesize a situation in which someone alleges that she, at the age of 12, was subjected to the tutelage of a sex abuser and saw him every Monday and Thursday of each week for an entire year. So there's 104 encounters, and maybe it took 4 or 5 before the sex became dominant as to what was going on, but let's say 4. So for the remaining 100 encounters, when they were together, that he abused her sexually. Now, under your language, you say for injuries arising from a single incident. So we're talking now about 100 incidents on Monday and Thursday of each week for the space of a year. Does that mean that someone can file suit for something that happened 60 years ago, allegedly twice a week, and allege that those are 100 separate incidents, each of which would carry with it damages of $1.5 million?
So this is the same line of questioning that Senator Sidnor, I think, just wrapped up with about 2, 3 minutes ago. But that language is again plugged from the Tort Claims Act, and so that's a judicial determination as to whether it's if it's 1 o'clock on Monday and 2 o'clock on Monday and Tuesday, Thursday, whether that is a single or act or a series of acts. So that's a case and fact specific analysis that, I mean, you just heard the colloquy between the professor.
I did. My response to that was I heard Ms. Hoke, Professor Hoke, talk about it. I frankly couldn't understand her answer. Wouldn't it be better for us to be specific as to what we intend rather than be ambiguous and then send it into the courts so there can be lots of lawsuits to figure out what we meant?
No, I mean, it's literally the way that the Tort Claims Act has been operating in law already. So,
well, I note it's different. This language is in section C. What is it? Something rather C. Excuse me, 5-117C is different than the language in 5303A, which talks about the liability of local government. In that case, it says in claims that arise from the same occurrence. So in C, you have the language arising from a single incident or occurrence. And then in A, it says claims that arise from the same occurrence. Was that intentional to have different language there?
I mean, it's intended to be this identical. So if it's not, then it should be. But the intent is to make it identical. It's literally plugged and repeated, so cut and paste. So I will, fix that drafting error, but that's certainly intent to make it the same.
And I think someone tried to answer this earlier, but why would a claim against a public entity be limited to damages of $850,000? Whereas, let me give you an example. In Roland Park in northern Baltimore, there are two schools right across the street from each other. There's the Roland Park Country School, which goes from first grade, maybe kindergarten, up to 12th. Right across the street, there's the Roland Park Public Elementary School, which goes from first grade to sixth grade. So let's assume that on the same day in 1952, a 12-year-old in each of the schools was abused by a teacher. Why in the world would we want to provide that the student who graduated from Roland Park Country School could claim $1,500,000 for each incident, whereas the student across the street in Roland Park Public School can only claim $850,000?
No, so I have to be careful in answering here because there are a lot of dynamics at play. And I told you, as that's why I made the case to mention that somewhat of a novel concept with the caps, period. And so if you talk, I think Professor Hoke addressed this issue actually with Senator Sidner again as well, that on the public side of the house, there, we have already absorbed some of that cost, those ancillary costs of the victimization and abuse as society at large, and public institutions have had to deal with that. Whereas it's not such the case maybe with the private sector. But the point is with private entities, the point is like, I've tried to here come up with some semblance of parity between private institutions and public institutions. And these are the numbers that I've come up with. And I've tried in earnest to create that parity that you're talking about.
Okay. Let me go over to page 7 of the bill, which provides, this is only I think relates to county boards of education. It doesn't seem to relate to county governments or the state government. It says each county board shall carry comprehensive liability insurance to protect the board and its agencies and employees. That language hasn't been changed, but in section B, it says the state board shall establish standards for these insurance policies, including a minimum liability coverage of not less than, and you've increased it from 400,000, you've more than doubled it, to $850,000 for each occurrence. Do you know how much more this is going to cost county boards of education to buy these higher amounts of insurance?
So the answer is I don't know, but look, the reason why that's adjusted is because the exposure has been adjusted. So you have to adjust the coverage amount. And for the smaller jurisdictions, they're in an insurance pool, whereas the larger, I think there are 4 or 5 larger jurisdictions that self-insure, and there's no reinsurance market here for this. Okay. So that cost, if it should exceed that $850,000 or whatever their coverage is, whatever their amount is, would then, if for the school boards in particular, would go to the counties. And so that's how that cost trickles up, because there is no reinsurance product out there to cover this.
Is there a fiscal note which would indicate how much the counties are going in extra insurance premiums the counties are going to have to pay?
I don't know if you could estimate that. It would be based on the number of claims that were brought in. I don't know if there's an easy way to estimate how many claims would be brought forth.
And of course, the current insurance policies are based on current law.
I would say just one kind of footnote is that if you were to create a window, you would have, and I thought this is a really good argument. You would have an influx of claims in a shorter period of time, whereas potentially if you had a long, if you don't have that window, then the cost is defrayed over the course of time, if that's compelling to you. But
well, just to pursue this line of inquiry, so these insurance premiums that are being charged to the school boards currently are based on current law.
That's right.
Which limits how far back people can file lawsuits. So if this bill gets passed, people are not only going to be able to file lawsuits within the current statute of limitations, but they'll be able to file lawsuits all the way back into the 1940s or 30s, depending on how old the person is filing the suit. So in order to cover that with insurance, the county school boards would have to buy tails. on their insurance policies. Have you any idea, A, whether such tails are even available and how much they cost?
I'm not an insurance person, but I'm not even like, all I know is the folks that I've talked to for the reinsurance, like, there's no reinsurance, and I don't know how the tails work on that. And I'm not even sure that's something that's a product that's available to a school board. So I can give you a more certain answer, but based on my conversations with folks in this space, I'm not sure that product is available.
So just to conclude this, if tail is not available, can't be bought
For a school board.
for a school board, and a school board gets sued for something that someone 80 years old alleged happened when the person was 10, and there's no tail and therefore no insurance, and a very large judgment is entered, the judgment would be entered against the school board, and somehow the school board would have to pay it, maybe sell facilities and raise the money to pay it. How would they pay such a judgment?
So again, based on the size, the smaller entities, if it exceeds the insurance cap, then the counties are gonna have to assist with that.
Okay, let me finish up by asking about the House bill. And I know you're not the sponsor of the House bill, but the simple fact is the House bill is different from this one. And if the two bills are passed in their current forms or close to their current forms by their respective houses, there will be a conference committee, and we will not have another hearing after the conference committee.
So I've just been told, I think the sponsor of that bill is going to be putting in conforming amendments so that it's exactly the same posture as this, what you see before you.
Okay, so the main difference, there are a lot of differences, but a principal difference is this bill allows public entities like public schools and county boards of education to be sued. The one over in the House does not. So if they conform the House bill to this one, the House bill will also permit public entities to be sued.
I think that's incorrect. I think that it does. It just doesn't. I'm not sure. It does. It just doesn't have the caps. It doesn't bump up the caps. I don't.
Okay, so the House will put the same caps on that are on this bill.
With the conforming amendments, yes, but beforehand, it still allowed them to be sued just at the current caps, which I think are 400,000.
Okay, great. Thank you so much.
Oh, thank you. Senator West asked quite a few of the questions that I was going to ask, but I would sort of posit that a lot of the concerns he raised would also apply in the private sector.
Yeah.
The insurance, the ability to get insurance. And one of the things that I'm not aware of, we do have states that are doing something, not anything identical to this, but are, trying different avenues. But I don't think any of them are recent enough or far back enough for us to know how this is going to affect the whole economy of the state, affect where their government can insure themselves or the private sector. But it occurs to me that if you have unlimited liability or even capped liability, but now we have a concern about incidence versus occurrence. So we could have 100 claims for 850 or 1.5 million. I'm concerned that no one's done any analysis of how this will affect the businesses that help children. I wouldn't be a private daycare worker if this or business owner if this happened. I wouldn't know. I couldn't get insurance. I don't know, in our zeal to try to rectify horrible things that have happened, how much we've given any thought to how it affects the overall economic interactions in our communities and all the people that rely on them. So I'm not asking you to answer that, but I think that has to be answered.
I do want actually, just as a sponsor, I want to, because you have the scope of what's happening nationally and the history of this, as you come up to here, but as a sponsor, I mean, controlling for some of that uncertainty, and this is a difficult dance to do because it's hard to talk about caps on something like this issue. And that's why caps provide a modicum of certainty in terms of your exposure.
But only if we know what incidents.
Understood. No. I mean, and so that's why, as a sponsor, I've tried to control for that. And then for the insurance, we've done a lot of research into how insurance works and what the tails look like. And, it's tough. It's tough. So I hear you, but I think for the national perspective, you have more experience on that.
Sure. Thanks.
Thank you. I think it's an important question, but what we've seen across the country is, for starters, services continue. Even in states as big as New York and California, no services have stopped. They continue, right? Even for the ones that have filed Chapter 11 bankruptcy, they continue, and there's no stop to services. We have data on this. What we also see is that in terms of the court system, right? in states, I think we looked at 11 states, and I can share that data with you. It might even be on my testimony, my written testimony. And that is that what we see is a very, very small percentage of the population are filing claims. I mean, on average, it's 0.25. Even in a place as heavily populated as New York, which is about 20 million people, it was 0.05. So really, really low numbers, just generally speaking. And again, that these organizations continue, all of the organizations continue their services. But I would like to point out something else, because I feel like the shift, and it's an important, and I agree with Senator West, these are important questions. So, but it strikes me as, quite frankly, as a mother, and as a reasonable person, that there is so much focus on the harm to institutions when the data doesn't really suggest that there's going to be a lot of harm other than some accountability. What strikes me is that the focus of the questioning is not about the harm to our children. Again, these are not typical torts. These are extraordinarily horrific torts that stay with victims their entire life. There's a public policy here that we should change our statute of limitations. And quite frankly, that's why 30 pieces of legislation have been filed across the country right now, because they're responding to this epidemic of child sexual abuse. It's not just the Catholic Church, right? It's families, it's coaches, it's teachers, it's ubiquitous in nature. COVID was bad, right? We all know COVID was bad, right? We lost over 1 million people in this country. I can tell you right now, 13.5% of children did not die of COVID in this country, but 13.5% of our children, and that is likely a low number, are being sexually assaulted. That is an epidemic, and I think it requires extraordinary action by legislative bodies such as yours. And that's why we're seeing this both across the state, right? We have 27 jurisdictions that have extended. We have, has eliminated, 27 jurisdictions have passed revival, and we have 17 jurisdictions that have eliminated entirely, including the federal government. So I guess what I would just like is to ask for us to focus on the real harm.
Thank you for answering the question. We want to make sure we are fully cognizant of the harm that has been caused here, but we do have an obligation to view this holistically, and we have an obligation to ask difficult questions. That's what we're here to do.
100%.
So, Senator James.
Thank you. Thank you for your answer.
Thank you.
I think that some of the confusion is what you've just said about what's happening across the country. And then I have a pretty detailed memo from, I think it's called ATRA. And they would, I think if you read that memo, I think they're pretty detailed at that. It's not as many states doing anything nearly that we are doing. So
I would disagree with that.
I hear you.
Yeah.
So I'll look at your memo and then I can compare them, and then I'll have to look at all the
Great.
statute. And this is probably for you, Professor. I read with great interest your most recent letter to us dated January 25th, and the really long AG's opinion from 1990 that's very dense. But I just wanted to make sure, because I understand that this Attorney General's opinion, said that back then the state could, change the section 5-108, which was a statute of repose relating to asbestos in manufacturers. But I don't think this opinion in any way said that you can retroactively revive time-barred claims. What I read the AG's opinion saying is they didn't find any vested rights. And I didn't see you, you don't need to do it now, but just respond later. I didn't see that you recognized that issue in what you said. You sort of said they got rid of this statute, but it was because Maryland really has never overruled its 100-year history of requiring that you can't go back and get rid of vested rights. What they did was a very strained opinion to get around it, saying we find no vested rights. So that to me is a little bit different, because I don't know how that would compare to the established issue here, which I can't believe we would say these aren't vested rights.
So they're not.
Right.
I'll be just frank with you. There is zero case law in Maryland that would say to you, that would in its holding say, when you create a statute of limitations or a statute of repose, you are vesting rights. And what we have is a 1990 advice from the Attorney General saying that's not the case. And we decide in Maryland what it means to have a statute of limitations or a statute of repose and whether that vests rights. And there is, no one can get up here and cite to you the case that says we are holding that you cannot revive these time-barred actions because the statute of limitations or statute of repose created vested rights and you can't unconstitutionally change that. That case doesn't exist. That's the whole point. So the underlying premise, I think, of the question is wrong because there is no decision here that says statutes of limitation or statutes of repose create vested rights. Quite to the contrary, the one time the Attorney General had to look at this in real time with a piece of legislation, they said it didn't, and that the statute of repose could in fact and was repealed to some extent with retroactive application, and claims that had been time barred before that bill became effective were revived. And believe me, cases were filed and settlements were had.
So it's your position that Maryland Court of Appeals does not hold that you can't retroactively infringe on vested rights. Is that your position?
No, I'm saying that a statute of repose or a statute of limitations, there's no case in Maryland that holds that a statute of repose or a statute of limitations creates a vested right that is so absolute that this legislature can't look at public policy reasons to revive claims that had been barred.
Okay. I got just be 1 minute.
Yep.
That may be all the questions I have for right now. Yeah, that's it. Thank you.
Any further questions for this panel or the sponsor? All right, we'll move on to our next witnesses. As this panel leaves, let me again say it's challenging for us on this issue, but I do think the questions that were asked are very much the appropriate focus and very much in bounds from Senator Sidnor and from Senator West and Senator James. I'll call up just based on the list, Mr. Chairman. Mr. Lorenz, David Lorenz, Judith Lorenz, Francis Schindler, and Susan Karen. Whomever would like to go first, please. Could you go to the podium, please? It's just easier for our camera. Thank you.
Good afternoon. My name is Susan Karen, and I'm the Executive Director of Catholics for Action in Maryland. And we were founded when the Pennsylvania grand jury came out with the clergy sexual abuse and cover-up. And as you may know, Cardinal McCarrick and Cardinal Wuerl were implicated in that. But I wanted to talk to you that 2 years ago, the Holy Father had done a synod process where all the laity across the globe could share their feelings about how they think the direction of the church was. None of the questions were political. And for something to rise up in the parish, it would have had to been echoed several times. And for something to rise up to in the diocese, it would have been echoed in a number of parish reports. So I wanted to read from you what was in the Washington, D.C. Archdiocese report. There were many expressions of mistrust of the U.S. bishops because of how clergy sexual abuse cases had been handled and the lack of transparency. While it was expected that Catholics would be upset by former Cardinal McCarrick, it was unexpected that many Catholics had such strong opinions about the bishops. Catholics across the political spectrum believe that the U.S. bishops are too political and are unwilling to apologize for the clergy sexual abuse. So our organization believes that
Survivors need to have disclosure, and that comes through civil cases. And we believe that this is the way for healing and justice and to protect the children. And we are asking for a favorable report without a watered down amendments. Thank you.
Okay, go. My name's David Lorenz, and I'm a survivor of child sexual abuse. I could talk about my abuse, but I've done that in past years, and it's in the record. You can go back and get it. In my role as Maryland Director for SNAP, a survivor support group, I often field calls from survivors who finally overcome the shame and the guilt that they're thrust upon them as children and reach out for help. Having received this permission, I want to tell you about one of those people. Keith is 62 years old, receiving state assistance after living a life that was not extremely stable. He had a wonderful youth in Baltimore despite being somewhat impoverished. He was not a Catholic, but started to hang out with a charismatic priest at the nearby Catholic church. Brother Mike was friends with all of the kids in the neighborhood and took them on trips. On one weekend trip to camp, Brother Mike repeatedly raped Keith. Keith was never the same after that. He was always afraid people would find out and think that he was, quote, less of a man. In his later teen years, he bought a gun to prove that he was a man. And that didn't end well, and he spent some time in prison. Keith told the AG's investigation team that other boys had been abused by Brother Mike, and that it was well known that the pastor, Father Sam, had at least one boy toy. Why this story? Numerous independent investigations of dioceses around the country reveal a disturbing pattern that the church regularly uses poor inner city and rural areas as dumping grounds for wayward priests. They know that these communities are too oppressed to speak if they think anything is amiss, and they are grateful to even have a priest. So the abuse continues, and these parishes are left with an overwhelming number of abuse victims. The Maryland AG's motion to disclose indicates the same behavior took place in Baltimore, where it states that, quote, although no parish was safe, some congregations and schools were assigned multiple abusive priests, and a few had more than one sexually abusive priest at the same time. One congregation was assigned 11 sexually abusive priests. The sexual abuse was so pervasive that victims were sometimes reporting sexual abuse to a priest who were perpetrators themselves, unquote. We don't yet know which parishes these were. Do you honestly think that it was done at affluent parishes? For all of the Keiths that were raised in the economically depressed areas of Baltimore and other cities, for those in the poorer rural areas were abused because of the diocese, dumped predators there because there was no one to push back. I urge you to rule favorably on 686.
Good afternoon. I am Judy Lorenz, asking for a favorable vote on 686. Here are my testimonies from a bunch of other years that I've been here. I recently stared at my computer and keyboard, wondering, what can I say this year to make a difference? I couldn't think of a thing. So I'm giving you the highlights from all those other testimonies, because I realize it's up to you to make the difference. 2015, my husband tried to tell me of his abuse before we got married. His attempt was convoluted, which often happens when survivors first try to tell their stories. From the little bit that he was able to share, my horrified reaction shut him down. 10 years later, he was forced to tell me because his perp was publicly accused. 2016, I come here again imploring this body to vote yes. I begged Chairman Valerio to stop stuffing the drawer and allow a vote to happen. I shared with a shaky voice the reasons why victims cannot come forward with their stories until much later in life, if at all. I sat with stomach churning and blood pressure rising as the opposition makes up stories about how harmful this legislation will be. So I ask, what are you going to do about it? I hope with all of my heart that I will not have to testify again next year. 2019. Survivors have been in this chamber for decades seeking this type of legislation. We need a look back window so past victims can finally be heard. This law will not guarantee survivors a big cash reward, just the opportunity to be heard and perhaps receive just compensation if a judge or jury deems it appropriate. Give them that chance. 2020, I'm here to say enough. 2021, this last one I submitted on behalf of survivors due to COVID rules. It starts with a survivor, quote, he then put a gun to my head and pulled the trigger. I quoted 15 more survivors and ended with this one. And then I am blamed for not coming out earlier. 2023, you see the pattern. You were voted in to make a difference. Please vote yes to SB 686 this year, and please make 2023 my last appearance. Thank you.
Good afternoon, Chairman Smith, members of the committee, fellow survivors and advocates. My name is Frank Schindler. I'm a survivor of child clergy sexual abuse and a member of SNAP. I support SB 686, which will send a strong message to all survivors and their abusers that the gross violation of the basic right of children not to be abused will no longer be tolerated in Maryland, no matter how powerful the source of that abuse. In 1954, a 5-year-old boy climbed a dark staircase and entered a room in a Catholic school to start kindergarten. A short time later, this boy was escorted into a room where a Catholic priest waited. The boy had been taught a priest is a representative of God on earth, and to question his actions would be to question the actions of God. Shortly thereafter, the boy was subjected to repeated and painful sexual abuse occurring 2 to 3 times a week over a period of 5 months. The basic right of a powerless 5-year-old not to be abused was repeatedly violated for the gratification of this Catholic priest. I was that 5-year-old. I am now 73 years old, and for close to 70 years, and for whatever remains of my life, I will suffer the consequences of that abuse. I'm a psychologist specializing in neurocognition and neuroscience. I could describe how trauma results in long-term dysregulation of neurochemical systems and alteration of brain regions, such as the amygdala, the hippocampus, and prefrontal cortex, and how this dysregulation distorts emotions, interpersonal relationships, and self-perception, and contributes to the reality that most survivors only recall fully their abuse after it occurs. Neurobiologically, the experience of trauma bears no timestamp. It is not recalled, it is relived. The lives of those subjected to sexual abuse and trauma are never the same, biologically, emotionally, or socially. For too long, the Roman Catholic Church has fostered the systematic, institutionalized sexual abuse of children. The Child Victims Act will firmly establish the basic right of children not to be abused for the pleasure and power of those entrusted with their care. I consider the Child Victims Act both a moral and a civil rights issue, and I respectfully urge a favorable report on SB 686. Thank you.
All right, thank you all very much. Questions from the committee? Seeing none, thank you all very much for being here. Okay, next we'll hear from Carolyn Zurich, Wendy Lane, Nancy Fenton, and is Reverend Little here? Is Kobe Little here? Okay. Ms. Schaub, Abby Schaub.
Sorry, I was just signed up for a written.
Okay, excellent. Okay. Meg Venton. And Miss Corzine, Mary Corzine. Whomever would like to start first, you're welcome.
Thank you for having us. My name is Carolyn Zurich. I live in Crownsville and Annapolis is my hometown. And I know that this is going to be a challenging afternoon for you all. I know it because I've been here before and the testimony is really, really difficult to hear. At a certain point, it's going to be hard to pay attention. You're going to start checking your email. You're going to look at your phone. You're going to make notes about things that aren't related to what's actually happening in this room. It'll be almost impossible to look here. If someone shows you a photo of the child they were when this terrible thing was done to them, you won't be able to square it with the person you're looking at. There's no relationship between that beautiful child in the picture and the broken person who's just trying to make it through their testimony. And this is what happens when decades pass and there's no justice. We can't move forward, we can't heal. The event that destroyed our childhoods continues to haunt us because indeed the child inside of us remains scarred. You don't need to decide if the school or the church is a different place now. You don't need to decide if the institution has changed. You don't need to decide who should be held accountable. Those are not your decisions to make. You just need to make it possible for us to have our day in court. you can help us. You can allow us to seek justice. Whether we find it or not, well, that's not possible to know. No one has ever been held accountable for what happened at Key School or Archbishop Keough or any of the other places that kids in Maryland went to school or to church with their parents thinking that they were safe there. Some of our friends have died, and for them, there will never be justice. And these institutions understand that if they can put off going to court for another year or another 5 years, there will be fewer and fewer of us. We're old. Do not allow them to win the war of attrition. And please, when you get to that moment today, when it's really hard, when it's just too much, just close your eyes for a second, inhale, exhale, and hang in there with us. We need you to know why this vote is so important. And then we need you to vote in favor of justice. Thank you.
Hi, good afternoon. My name is Mary Corzine. I'm a survivor. When I found the courage to come forward, I was told you'll feel better if you forgive him. Vengeance belongs to God alone. It's probably better to just let it go. And I wonder, is it any wonder that victims don't come forward for decades? I tried to tell my parents, but became overwhelmed worrying about what would happen next. I didn't know the words to describe what was happening. I was in 5th grade when I was instructed to sit on the abuser's lap in a dark room in an empty house on school property. I thought he had a stick in his pocket poking at me. I was told to wrap my arms around his neck while he talked to me. When it was over, I flew outside, red-faced and crying, and went to the school bathroom. My uniform was wet with a substance that was unidentifiable to me. I wiped it off and returned to class, feeling both numb and overwrought. This happened several times, also in the boiler room in the school, where I was placed across the top of a child-sized desk hidden in the back. I told a teacher about the abuse. She never told my parents. My abuser was then moved to a different parish. In 1986, I learned an 8th grade boy had attempted suicide after being abused by the same priest. He later pleaded guilty to 4 counts of sodomizing a minor, admitted to sexually abusing 6 other boys more than 50 times in the previous 6 years. He took a plea deal that granted him immunity from prosecution for abusing the other 6 boys. It's heartbreaking to me that a person can commit repeated, constant, and calculated pedophilia in Maryland and get away with it. He is a perfect example of how abusers will continue to abuse unless they are stopped. This bill will help expose abusers like him and protect children in the future. When victims come forward, perpetrators are exposed and children are safer. Predators depend on the statute of limitation to be able to continue to practice their compulsions. And even worse, institutions further protect abusers when they consistently demonstrate a lack of courage by protecting their institutions rather than its victims. Thank you so much for your time, and I'm grateful to be here. Please support Bill 686. Thank you.
Good afternoon, Chairman Smith and members of the committee. My name is Wendy Lane. I'm a pediatrician. I'm a child abuse pediatrician, and I'm a public health professional. And I am here in support of SB 686 on behalf of the State Council on Child Abuse and Neglect, which I chair or SCAN. I'm also here on behalf of the Center for Hope from LifeBridge Health. And I'm here on behalf of the Maryland chapter of the American Academy of Pediatrics. I had a whole list of things I was going to talk about today, but I wanted to actually kind of throw that away and specifically address Senator James's comments about the fact that or her concerns that if we pass this bill, then that would mean that insurance people won't want to open daycares because they won't be able to get insurance and they won't be able to get coverage. My response to that is that child sexual abuse is a preventable act. There are policies that we can put in place and that should be put in place in institutions, in child serving institutions, that can keep these events from happening.
Insurance companies are businesses. They want to insure organizations, and it's up to those organizations to demonstrate that they have policies in place. This is not rocket science. I work at Center for Hope. One of the things that we do is develop policies to protect children. And we are now working with some private schools. We're working with public schools. We work in our own agency to put policies in place to make sure that children are protected. This, again, is not a random act. This is something that can be prevented and needs to be prevented in the future. I strongly urge you to support SB 686. Thank you.
Good afternoon. My name is Meg Venton. I strongly support SB 686. I'm not going to talk about what happened to me. It's a matter of record, Washington Post, August 19th, 2018. I will say that when I told my guidance counselor about this perpetrator, when he was trying to determine why I seemed to be psychologically and academically crashing, his reply was, "I know, baby, I've got eyes." Dozens of perpetrators, dozens of victims were involved at this school. Only one person was fired to my knowledge, and it was done quietly. I will say that what happened to me has had a profound influence on my life, on my relationships, decision-making, emotional and physical health, and my ability to trust anyone to not be a predator. I have to work every day to minimize its impact with many hours of cognitive therapy, and I'm coming up on being a senior citizen. It's tremendously difficult and frightening to report sexual abuse at any age, but when one is somewhat older, one has a better chance of withstanding the tremendous emotional fallout, the horror, pity, disgust, isolation, the excruciating feeling of exposure. Please help us shift the burden of this sort of damage off of the taxpayer and rightfully onto the shoulders of the institutions that used us with such impunity. Let's also expand the threat against future pedophiles and the institutions that shelter them. Let's save some lives. For these reasons, I respectfully urge a favorable report on SB 686. Thank you.
Thank you very much. We have a question from Senator West.
Thank you, Ms. Surrey. Could I talk to you for just a moment?
Sure.
Your testimony was very powerful.
Thanks.
So let's hypothesize that there's a dental practice out there.
Mhm.
And the current owner of the practice is Dr. A,
Mhm.
and he bought the practice some years ago from Dr. B, and he bought the practice from Dr. C, who brought the practice from Dr. D.
Right.
And Dr. D owned the practice back in the 1950s.
And he's dead.
And he's dead.
Right.
But he abused a number of children, young girls, in his dental chair back in the 1950s. So you heard during the first panel two templates for how we could approach this. One is to form a victims fund, which people could make claims to, and the other enable people to file suits for things against the current owners of businesses, the things that happened in those businesses many years ago when the current owners may not even have been born. So a suit against the business could put the business out of business, even though the current guy who's running it bought it in good faith, had no connection to what happened in the 50s. And the other is the victims fund. Which do you think would be the preferable way of going?
That's a really interesting question. And I have another really interesting question, which is, you know what Johnson & Johnson has done about shifting the asbestos claims? They made a very small company which had no assets. So then the asbestos claimants could not get any kind of compensation because Johnson & Johnson had spun off. So I'm actually really curious about what is going to happen when institutions say, well, I am no longer the Key School, I am Key School, I've changed who I am, and so you can no longer bring a case against me. But the question that you asked that I think is also really interesting is, and I think Megan really had an interesting part of that, which is who should we as taxpayers be bearing any of the cost of the bad acts of institutions that no longer exist? And I wonder about that as
Anne Arundel County resident and as a taxpayer, whether that's something that I would really love to do as someone who's also a survivor. That would be like so deeply ironic if I'm into a fund that was going to support people who had been sexually abused. That's a little hard to go, a place that's hard to go, but I hear what you're saying. And I actually think that the number of cases that might come out of the situation that you described would be infinitesimal. It's really hard for us survivors to come forward. It's really hard for us to even think about bringing a case. Nobody wants to go to trial. Nobody wants to sit in front of a jury or a judge and explain the horrible things that happen to us. I mean, it's torture, like literally torture. So I would be really surprised if there was somebody out there who'd been at a dentist in 1955 who had abused them, who was now 75 years old and decided that what they wanted to do was to go after an institution that no longer existed. I mean, I guess it's possible, but I would really, really be surprised that somebody would have the courage, will, desire, and enough life left to see that through.
I'm not sure. Well, just to quickly respond, Ms. Jordan and I were talking about the possibility of the Attorney General bringing lawsuits against perpetrators and those who harbored them to get the money to populate that fund.
Right.
So,
right. Most of the perpetrators aren't rich. It's the institutions that have money. I mean,
I'm saying the institutions that harbor them.
Well, so, right. I mean, but that's the problem, right? The dentist, their institution isn't the same institution anymore.
That's sort of the point I was making. Thank you
Right.
very much.
I know
for
it's
your
really
answer.
complicated.
Yeah, thanks.
All right, additional questions from the committee. Excellent. Thank you all very much. Thank you for hanging in there with us. Next is Paul Griffin here, Teresa Lancaster, Hay Connors, and Donna Vondenbosch. Is Gemma Hoskins here? Ms. Hoskins? All right. Paul, if you want to get started.
Thank you, Senator, and thank you, members of the committee. My name is Paul Griffin. I'm the legal director of Child Justice Incorporated. Child Justice is a nonprofit organization that litigates child custody cases involving child sexual abuse, amongst other things. We deal with this topic virtually on a daily basis, and we know the harms that are inflicted on children from child sexual abuse. But in our cases, the abuse and the perpetrator have been identified. And if things go as they should, the victims receive the help they need. But victims of unidentified child abuse take years to recognize and disclose their trauma to others. The average age for adults to disclose childhood sexual abuse is about 52 years old. Victims often develop coping mechanisms to deal with child sexual abuse, such as memory repression, denial, and dissociation. Elimination of the statute of limitations and statute of repose and implementation of a look-back window would enable adults who were sexually abused as children to seek justice for the harm they have suffered. It would shift the costs of abuse, including years-long medical and mental health care, from victims to perpetrators, including those institutions that hid and protected sexual predators. But equally important is the protection this bill affords children today. We must remember that predators don't stop abusing children when their current victims get older and age out from their perspective. They simply move on to new child victims. A look-back window will help protect current children from being abused because hidden predators are frequently discovered through civil discovery process and reported to law enforcement. Look-back windows in other states have identified literally hundreds of predators. Now think about that for a moment. This body has the ability to help remove current child sexual abusers from the communities in which they prey. This isn't just looking back at somebody who abused someone 20, 30, 40, or 50 years ago. This is current and active abusers. Some opponents of the bill have raised concerns about bankrupting institutions and leaving them unable to provide needed education or social services to low-income individuals and others. Simply put, these concerns are unfounded in our belief. Institutions, two more paragraphs if I could, Senator, I'm sorry. Institutions that have filed for bankruptcies have done so under Chapter 11, which allows them, the debtor, to create and reorganize and maintain their business while they pay creditors over time. And additionally, in just one example, nearly 77% of the Catholic Charities of Baltimore revenue comes from governmental agencies as payment for services provided, and those funds may not be used to pay settlements or judgments. So this bill would have no effect on that funding or the ability of organizations to provide these much needed social services. So we urge a favorable committee report and passage of Senate Bill 686 without amendment. Please eliminate the statutes of limitations of repose and implement a look back window for adult victims of child sexual abuse. Thank you.
Thank you very much.
Good afternoon, members of the committee. My name is Teresa Lancaster. I'm an attorney, I'm a survivor, I'm an advocate for victims of childhood sexual assault. I was abused in my high school by a counselor there named Father Maskell. You may know me from the documentary, The Keepers. I was unable to come forward about my abuse in the 1970s because Maskell convinced me I would not be believed, and he threatened me with his gun. I feared for my life. This is common among survivors. Why? The severe nature of the trauma endured, coupled with the often high social position of the abusers, are factors that prevent survivors from coming forward earlier. Other factors are depression and substance abuse. I struggled with the fact that my abuser was someone I trusted. Maskell was assigned powerful positions as a police chaplain, as well as a military chaplain for young recruits. He always had access to young victims. Through my work helping survivors, I learned that Maskell abused kids as young as 3 years of age. Cardinal Keeler knew my 1994 Doe Road case was credible, but used the statute of limitations to make it go away. As a direct result, Maskell was given free rein to continue abusing children. The Catholic Church has a long history of hiding their pedophile priests and shipping them from parish to parish. I respectfully ask you to pass Senate Bill 686, the Child Victims Act of 2023. This bill will provide a path to justice for victims ready to come forward, help identify hidden predators, and disclose facts of the sex abuse epidemic to the public. Thank you.
Hello, my name is Donna Vandenbosch. I'm a survivor of Father Maskell and sexual abuse. And he prostituted me. He prostituted me to other priests, and I can say names, but I'd be polite. And priests, police, and other men. I am here for my school friends who are not. Those that were suicidal, had drug problems, overdosed, and alcohol. I strongly support Senate Bill 686. It would be, after decades of my suffering, a sense of justice, and enabled me to think that maybe future people, little children and people, would come forward and be healed. For closure, I want to say I feel that so much injustice of the people, my teachers that stood around and told me they knew that the abuse was going on, because I would cry, don't send me down to his office. And I want this to cover, mandatory people should be reporting these things. I'm not going to go in how my life had changed so much, but I am for closure of these heinous crimes. The people that knew Father Maskell had issues and stood there and did nothing were just as guilty, trying to save the school. Please pass this bill so I can feel like a sense of justice and my life is worth something. Thank you.
Good afternoon.
My name is Gemma Hoskins. I am from Baltimore, Maryland. I am a retired educator, former Maryland Teacher of the Year, and yes, the whole cast of The Keepers is here. So you may know me from the series as well. I'm here today, though, as an advocate for some survivors who are not able to tell their story publicly. And I work with a lot of them, and one of them has given me her gracious permission to tell you about what happened to her. So I'm going to ask everybody in this room that has a family member under the age of 5 to raise your hand. It might be a child, a grandchild, a great-grandchild. It's a lot of precious children. The woman I'm referring to was 3 years old, 3. She was taken with the knowledge and permission of her daycare providers from the daycare playroom in a large Catholic parish in South Baltimore. And she was taken to the basement where the parish priest told her they were going to have fun and make a movie. He blindfolded her. He had young teenage boys molest her. And at one point she told me she thought she was holding onto an umbrella handle. It was not an umbrella handle. On another occasion, the priest told her her father was going to meet her for lunch at the cross street market. So he walked her down the block, and when they got to South Charles Street, he tried to sell her to men in cars. Nobody took him up on it, but nobody reported a priest and a 3-year-old prostitute on the corner of South Charles Street. Because this child, this wounded adult now, was so young and so tiny, he could not penetrate her sexually. He put her on a dining room table and he raped her with a crucifix. I am begging you, for her sake and that of all children and your own children, to please pass the Child Victims Act this year. Thank you.
Thank you all. Questions from the committee? All right, seeing no questions, thank you all very much. Thank you. All right. Is Kay Connors here? Sarah Conaway? Linda Boyd? Kurt Ruprich? Jennifer Gross? Did we hear from Kay Connors? Did I get Kay Connors? Kay's not here. Okay, got it. Thanks. Thank you. All right. And then David Chappelle. Is it David Chappelle? Okay. We start whenever whomever would like to go first.
Thank you for the opportunity to testify before the committee today in support of the Child Victims Act. I'm Sarah Conway. I'm a survivor of childhood sexual abuse at the Key School by 2 of my teachers when I was 14 years old. In 2019, an independent investigation concluded that at Key 10 perpetrators abused 16 students, and the faculty and staff and administration and board members were aware of the abuse and chose to remain silent rather than intervene or report it. It may be hard to conceive of how hostile the environment was for victims in the past, and even now when we report, we may face tremendous blowback from our school or church community, and law enforcement prosecutes only a tiny percentage of our cases. When my parents confronted Key about the abuse, the school only shrugged. When they consulted the Anne Arundel County State's attorney at the time, he strongly dissuaded them from contacting law enforcement because at that time, how harshly victims were treated. The quote I remember is, "She'll be destroyed on the stand." The civil statute of limitations expired for me at 21 when I still had few words for the pain and confusion I felt. I spoke out publicly in 1993 and the school said that they didn't have any institutional responsibility, wasn't their problem. And in 1997 and 2018 and 2019, I spoke with Anne Arundel County Police, the state's attorney's office here. And despite being penetrated every which way, they are not sure if it was a felony at that time. Anybody would consider it rape today. So civil action is my only recourse. Being turned away, silenced, and shamed by one's school and law enforcement over decades is devastating. Institutions are causing real harm, not just by allowing the abuse, but by covering it up, shutting us up, silencing victims. If it's for these reasons that I ask you to please favorably report and pass the Child Victims Act. Thank you very much.
Good afternoon, Senator Smith, committee. Thank you for this opportunity. My name is Kurt Ruprecht, Forest Hill, Maryland, and I am a survivor of childhood sexual abuse, speaking in support of the Child Victims Act. I was groomed, sexually and violently assaulted by Father Joseph A. McGovern when I was 8 and 9 years old in Salisbury, Maryland. I've submitted my written testimony. It goes into all the details. They are gruesome, diabolical. I think you get the picture. I humbly ask that if you are undecided on this bill, to read my account, but I need to leave you specifically with these points because frankly, this may be the most important 2 minutes of my life. Number one, there is no true healing from this type of childhood trauma, only survival. Number two, I feel this is my duty to report, and I use that term specifically. Please understand the larger picture of how I came to be abused as a child of the Diocese of Wilmington who lived in Maryland. In the Diocese of Wilmington, 85% of the parishes had predator priest assignments during the 1960s through 1990s. We know this because of the 2007 Delaware Statute of Limitations Reform Law and Look Back Window for survivors. That legal discovery, empowered by the Look Back Window, released the documentation proving the Diocese of Wilmington protected their predator priests and exposed the Wilmington's explicit strategy to avoid exposure in Delaware by concentrating their predators within the Maryland parishes. Parishes in Delaware contain 79% of the diocese members and average 2.4 predator priest assignments per parish. Maryland contained only 21% of the diocese members and averaged 7 predator assignments per parish. Do that math, and within the Diocese of Wilmington, Catholic children on the eastern shore of Maryland were 11 times more likely to be exposed to a predator priest. My predator is still alive. My parents are still alive and can corroborate the times and places of my abuse. I deserve my justice, but unfortunately it occurred in Maryland where my justice is delayed and truly denied. Please finally remember the Child Victims Act is for all of our citizens, survivors from the past, as well as our children today and tomorrow. I realize my experiences are with the one entity that consistently fights this legislation. However, no institution of any kind deserves the power to deny justice to those of us who are broken and deny protection to our children when they are vulnerable. Please hear us. I implore your support for SB 686.
Good afternoon. Thank you for having me. My name is David Chappelle. I strongly support SB 686. It will give me and so many other survivors an outlet for closure, healing, and assurance. I live in Ellicott City with my wife of 20 years and our 5 kids, aged 5 to 16, whom my wife is raising Catholic at St. Louis Parish in Clarksville. I'm the director of HR at a government contractor headquartered in Columbia, Maryland. I'm 45 years old, and I'm a survivor of child sex abuse and rape. In spring of 2019, I began to recall horrific, repressed memories of being sexually abused repeatedly and raped by a Catholic priest during the fall of 1986, when my family had just moved to Gaithersburg. I was 9 years old, starting 4th grade at Diamond Elementary and religious ed at St. Rose of Lima Parish, which is where my abuse occurred. My abuser was then Father Wayland Brown from Archdiocese of Savannah, Georgia. He was in Maryland at St. Luke's Institute in Silver Spring, which is a treatment facility for pedophile Catholic priests. Yet he continued to have unchecked access to children like me. He died in 2019 while serving time for raping other children back in Georgia after he left Maryland. He was never cured, but rather he was protected and enabled. A few months ago from now, a few months ago, I recalled a stark memory of bedtime the night after I was raped at gunpoint during a church picnic for kids. I laid in my bed, looking up at my ceiling. My 9-year-old inner self was trying to deal with what had happened. My rear was still sore, and I was too embarrassed, confused, and scared to tell anyone what happened. I told myself then, forget everything and just try to live a normal life like everyone else. I didn't want to be different or let this hold me back. These past 4 years, I've been reliving this trauma as I remember new things. People around me seeing the intense effects on me. Some of my family have even been dealing with collateral damage. I lost 30 pounds in about a month. I'm managing my PTSD, anxiety, and depression through ongoing therapy, medications, all totaling over $60,000 so far. Closure to me means getting answers and acknowledgement from parties involved, financial help to pay for my family's ongoing therapy, and importantly, to have assurance that this is not still happening today. For these reasons, I respectfully urge a favorable report on SB 686. Thank you for your time.
Good afternoon. Thank you, Chairman and other members here. I'm here in strong support of this bill. My name is Jennifer Gross. I am not a survivor of childhood sexual abuse, unlike these amazingly courageous people here with me and in this room and watching. I'm here as a strong advocate, as an outraged citizen, and as a professional in the field. I've worked for 29 years, specifically in the field of sexual abuse. I've investigated abuse. I'm a certified sex offender treatment provider. I do forensic evaluations and treatment. I've worked for the Catholic Church as a diocesan coordinator of safe environments. I teach their prevention class. I'm here, I would like to address a few undercurrents in this room and a few undercurrents in our society as a whole that directly influence the decisions some of you will be making today. Number one, do people lie about sexual abuse? We hear about allegations 90 years ago, 80 years ago, 70 years ago, 6 years ago, 2 weeks ago. Do people lie about abuse? Yes. Every single person I've ever met in a 30-year career has lied about abuse, but they didn't lie that it happened. Abuse is rarely made up, extraordinarily rare that someone will make up abuse. What does every single person I have ever met, personally and professionally, lied about? They lied that it happened. They lied that it didn't matter. They lied I already forgot about it. They lied it's not that big of a deal. They lied mom stopped crying. They told their teammates, don't worry, the coach we won't have to lose our season. They lied about the impact. They lied about the toll. They lied about the horror. That's what victims lie about. They don't lie to make it up. These people need justice. Nobody's here to bash or destroy youth serving organizations. Nobody's here to do that. I'm a Catholic. I'm begging you to pass this, not to destroy the church, to save it from itself. Allow these people justice. Open the door so they can seek justice, please. And speaking as a sex abuse treatment provider in a program that polygraphs offenders, I can tell you in all my years of doing direct treatment, I've met one person that's only had one victim. Every single other person I have worked with professionally has multiple victims over the course of many, many years. This bill will allow people a door to justice
that will be torturous in trying to achieve it for them if you're witnessing. And it will also help uncover people who are currently hurting children and the institutions that have knowingly, willingly decided to protect and enable them. For those reasons, I beg you to urge a favorable report on this. Thank you.
Thank you, Ms. Gross. All right, questions from the committee? No, we've got a few more folks. Seeing no questions, thank you all very much for your time. Oh, I'm sorry. Senator Carter has a question.
Thanks so much. I apologize that I missed some of the earlier testimony. I had a bill in another committee, but I'm planning to go back and look at what I missed. And so I'm sure that in earlier panels, there might have been somebody that might be more equipped to answer my question, but I was particularly moved by the testimony of the last witness. Because as a Black American and a Black woman, I feel like we live lies all the time. We have our reality, and then we have the way that we pretend in the world that the injustices that we have endured and continue to endure are okay, and that we're okay, but we're not. So I'm moved by that. But I am, and I don't know if this is for your panel or someone that's maybe in the earlier panels, but according to the Pew Research, 32% of Catholics in Maryland are of color. But I don't see that represented in the group that comes to testify. And I'm wondering, what is the reason that you believe that is? Is it because you think that Black and brown people are not enduring this kind of abuse in those numbers, or are they just more reticent to come forward? Or is there a lack of an outreach to get them to come forward? What do you attribute that?
In my experience in working in the field of abuse for 30 years in many different roles, it's extraordinarily difficult and unlikely that a victim will come forward at all. It's rare that a victim talks about abuse when it's happening. The average age of disclosure is in their 50s when people come forward. That's compounded for minority and other oppressed groups, economically disadvantaged, and other groups like that, because there's so much additional stigma. It's rare for men to come forward. It's rare for women to come forward. It's even more rare for men to come forward because there's additional stigmas attached to that. With our minority groups, there are more reported, as I'm sure you've heard in other legislative sessions, there's more abuse reported and investigated against minority groups because of systemic racism and issues. I think that they're less likely to come forward because the world has taught minority groups that they won't be believed, that they're not valued, even more so than people who look like us on this panel. And I think that surmounting that systemic racism, historical racism, oppression, and then to come face this on top of it all. In my experience in working, and I'm fluent in Spanish, I've worked over the past 30 years with immigrant populations who have a lack of English. Many of them don't speak English. They're not familiar with our laws, and they come from societies and countries where there is no protection. And we at least talk about it here some. And many of these people I have worked with come from countries where it's not even spoken of. And so I think that our people of color and our minority groups carry additional burdens and have to cross additional barriers to come before a legislative body as yourself and dredge up the most painful, humiliating aspects of their lives, when most of the time they perceive, based on past experience, it's futile. They won't be heard. They won't be listened to. When people who look like me come year after year after year after year after year, we had very moving testimony by Ms. Lorenz, years of testimony, and felt unheard. I think that's an additional burden that places barriers for people that already experience oppression in so many other ways.
Senator, thanks. Thank you for that. Senator Carter, any follow-up? Yeah. So, and additional questions from the committee? All right, thank you for that, Senator Carter, and thank you all very much for being here. Thank you. Did Linda Boyd, all right, Linda Boyd Vanessa Milio. And then we have a couple of virtual attendees, but let's go through. Let's get, is Mary Beth Diaz here? Kenneth Phelps. Mr. Phelps. Yeah. Vanessa's there. And then is Mr. Percy, Davion Percy, sorry, right there. Daniel Robinson.
He's here.
Sorry.
Before I start my testimony, could I respond to Senator Carter's question? Is that possible? Senator Carter, my name is Vanessa Milio, sorry. I don't know if you're familiar with, but the Jesuits across the country decided to look at this issue of lack of representation in Black and brown communities around abuse, particularly clergy abuse. And Loyola University here in Maryland was charged with taking a look at Baltimore's situation, and their report is really worth the read. I would not do it justice to summarize it for you, but I would be happy to get it to you. Or did you participate? Is that what you're going to tell me? And I should know that.
Oh, I find it astounding, and I'm very interested in reading it. As a graduate of Loyola University, I find it ironic that they would be the ones to issue such a report.
Well, I will reserve my own judgment for that perspective, because I also found it surprising, but it was actually pretty thorough, and it's part of a research project that's happening across the country. But Loyola's University of Maryland's specifically focused on Black and brown communities in Baltimore as it related to abuse within the Catholic Church. So I'm happy to follow. And it sounds like Senator Washington, you might want to see that too, by your head nodding. Happy to send that to you all. Okay, sorry. All right, you've listened to some heart-wrenching, gut-punching testimony today. I've been working with survivors on legislative issues around this for 5 years now. Hearing their stories gets me every single time. I also know that it is so much easier to focus on the intellectual discussions around legal implications and fiduciary responsibilities than it is to focus on the social and moral impacts of what you've heard today. I come to this work from a long career in the nonprofit sector. My expertise areas are organizational development, communication, which means I spent a whole lot of time crafting policies and procedures, spinning talking points, and training staff around prevention. What this work has taught me is that we tend to approach things from a single lens. We focus on the issue in front of us and not the dominoes that fell to create those issues. I'm sure you're all familiar with the story of the kid on the beach throwing the starfish back in the ocean, and the adult says, "Oh, you can't save them all." And the kid says, "Oh, but I saved this one." Well, I've always hated that story, because my question is, how did all the damn starfish end up on the beach to begin with, right? I want to know how we got to this point. With this issue, we have the tendency to listen to the story and focus on the experience of the individual. But let me be clear, I am not asking you to dismiss their stories or relegate them to things that happened years or even decades ago. What many of them did not share is the impact of their abuse on their spouses, their friends, their children. The impact of childhood trauma is intergenerational. We know this anecdotally and scientifically. Our brain chemistry changes when we experience extreme trauma as children, and that change is passed on genetically. Families often talk about how diabetes or breast cancer runs in their family, but they don't mention depression, autoimmune disease, or rage control. Society, all of us, are already paying the price for the impacts of child sexual abuse. Research shows correlation with eating disorders, with substance abuse, with sex trafficking, with incarceration. We collectively pay for those impacts, either directly in our own families or indirectly in the services our state provides to mitigate the damage. We also know that there are proven prevention strategies that minimize the impact of childhood trauma and foster resilience in all children, and we are a long way from funding and implementing those strategies in a widespread interdisciplinary manner. What does this all mean for the legislation that's in front of you? I simply ask that the conversations you have and the decisions you make be grounded in a solid foundation of justice for those whose voices you've heard today and for those who cannot speak about their trauma. I am not naive to the fact that there will be financial repercussions if this legislation passes. I am simply saying that I believe it needs to happen in order for us to heal. Thank you.
Good afternoon, Chairman and members of the committee. My name is Mary Beth Diaz, and I am from Baltimore, Maryland, and I am a child of a survivor. My mother has given me permission to come and tell a little bit of her story, but my main focus on how child sexual abuse affects a family. My mother's predator was a clergy member, and she was taught to believe that she could trust this clergy member. Her recollections of the abuse started, and they were like movie clips that played over and over in her head. And maybe it was best that she was drugged or hypnotized. My mother's life split into two minds that night the abuse started. She lived every day of her life in conflict between the young teen who was brought up in a strict, traditional blue-collar family and the young woman who was now the mother of a child. Her life spiraled down a path that was driven without direction or concern for her well-being or for those who had responsibility to her and to other children to be kept safe. My mother is amazing. She's loving, she's talented, she's strong, and yet very, very broken deep down inside. And the hardest part for me as a daughter, I can't fix it. You, however, can give us the opportunity to try and help her. Not just for her, but for all survivors of child sexual abuse. My life was changed before I was even conceived by the abuse that she should have been prevented. So it's not only survivors that we need to pass this bill for, it's the families, the sons, the daughters, the parents, siblings, and friends of survivors. Please give me the opportunity to say to her, I can't fix it, I can't change it, but we are going to be able to have an opportunity to try to get some justice. I urge you to rule in favor of Bill 686. Thank you for your time.
Good afternoon, Mr. Chair, Vice Chair, respective members of the committee. For the record, I'm Davion Percy, and for those of you who know me, this is usually the point where I would let you know who I'm representing today. But I want you to know that I'm not representing any client. I am not here as a regulated lobbyist of Maryland. I am not paid to be here. I'm not representing my firm, our clients, or its employees. I'm representing myself as a citizen of Maryland and a victim of child sexual abuse. Over the course of about 7 years, I was molested multiple times by 3 different men who were entrusted in my care, one associated with an institution that was entrusted in my care. I also grew up and still remain friends today with friends of mine who went through that with these same people. And forgive me, this is the first time I'm speaking publicly about this, and this is the first time in my career that I speak before a legislative body without actually even getting paid for it, because I know this is right. This is the right thing to do. There are children who leave our homes whole and return home broken. And I was one of those. Every year, I've watched this hearing from my office, on my laptop, and I've commented on it in the back hallways and with the advocates. But this year, I felt strongly about coming forward because I suffer from this. I've destroyed relationships, friendships. I've been through divorce. I have problems trusting people. The reason why I like what I do today is because every day I get to help people. But what good is my word if I don't stand up to speak on what's right? So I'm asking this committee to really take a hard look at this bill. And please, please vote favorably, not just for me. I can't seek justice for several reasons, including the fact that all 3 of my perpetrators have since passed away. But for our future. So I urge a favorable report. Thank you, Mr. Chairman.
Before I get started, just a couple of preliminaries here. I'll move this up so you all can hear me. There, okay. Want to welcome Senator Washington to the committee. As a lifelong Prince Georgian, hope we get to work together and make Maryland a better place for all of us and our children too. Senator Carter left. I wanted to relate an experience that I had this summer. I have a lot of family in Minnesota, and my grandmother grew up off of Lake Street, which was about less than 2 miles from the murder spot of George Floyd. And while I was there, I took my son, 15 years old, and we drove by there. We stopped and got out and walked around a little bit. We had a synthetic rose. We went over and put it over there and talked to a few people. And at first they were a little nervous, understandably so, but they warmed up to us, and we had a good experience. I call it a teaching moment for my son. But Senator Carter asked an interesting question, and I think we need to do a better job of reaching out not only to the people of color, but to all sexual survivors. The Attorney General's report says there's over 600 people in just the Archdiocese of Baltimore alone who came forward. That doesn't count the hundreds who didn't come forward. And we ought to have to ask ourselves, what can we do better to get these folks to come forward and tell their stories so that everybody knows how bad things are? So, to the Honorable William Smith, the Chair, members of the Senate Judicial Proceedings Committee, from Daniel F. Buddy Robeson Jr., February 23rd, 2023. Dear Senator Smith and members of this committee, as you look at the attached picture, I think everyone got a copy of it. You look at the attached picture, I'm sure it seems innocuous enough. It's a picture of my son and me, who is attending his first day of school as a 6th grade student on August 29th, 2019. His birth date is January 15th, 2008, and he is 11 years old in this picture. Thousands of fathers nationwide most likely post for the same picture with their sons every school year, but unlike others, there's a backstory to this picture. My son, Sean, was the exact same age I was when I was sexually abused by a Catholic priest by the name of Timothy P. Slevin. Yes, I'm a Slevin survivor too, just like Mary Corzine. Slevin is a perfect example of a priest that they moved from one parish to another, to another, to another. Signed to St. James Church School in Mount Rainier, Maryland, Prince George's County. The pain of my abuse lay dormant in my memory for many years, but has come back full force with the revelations of Theodore McCarrick, subsequent resignation of Donald Worrell for his part, and covering up the abuse as revealed in the Pennsylvania grand jury report. It is still too painful for me to talk about, and I really thought I'd take my secret to my grave. I will turn 68 in December this year and still live with my secret. It has been a very hard road to have to live through the pain of my abuse again. As a father and a parent, I look at my son. Sometimes I cry, but I mostly pray. That he'll never know the pain that I went through, what I'm going through now. Nothing and no one will be able to take back what was done to me. But if I can do anything at all to prevent my son or anyone else's son, daughter, from having to experience pain at the abuse in the hands of a pedophile predator, then my efforts today and every day will be worth it. For these reasons, I urge a favorable committee report and passage of Senate Bill 686 without amendments, most sincerely. I want to leave you with a quote. I leave everybody with a quote. And we celebrated this gentleman's birthday about 5 weeks ago. And I'm going to ask you today, this committee, to honor his legacy and his memory by just simply, time is always right to do what's right. Gentlemen, people, everybody in here, do the right thing. Honor Dr. King's legacy. Do the right thing. Dr. King had a tremendous impact on me as a child. I remember his speeches. I grew up in a little town right by the DC border. I remember his assassination, and I remember the unrest in the aftermath. That was a traumatic summer for me, 68. A lot of things happened. So I'm going to ask you folks, just simply do the right thing. That's it. Thank you very much.
Thank you. First, it's always great to see another Prince Georgian here. So great to see you, sir. And Mr. Percy, I just want to say thank you for sharing your story. Very powerful. And everybody else here
that shared their story. Very powerful testimony here today. So I know it's not easy coming in front of us to speak, and so we're really appreciative of that. I do have a question for Ms. Milio. About my colleague, Senator West, brought up the idea of a fund. I thought it was an interesting idea. Can you just give us your take on it, what you think about it? Good idea, bad idea, indifferent?
I don't know that I'm allowed to say indifferent. So I have I have some apprehensions about a fund. So there have been other instances where funds have been set up. The easiest example is when there's been a natural disaster, the Exxon Valdez, the oil spill, or the BP oil spill. They set up a fund and everybody works through this one magistrate to get their awards, right? Have there been issues where that occurred in child sexual abuse? Yes, there's been cases, the Nassar verdict in Michigan, right? Where you had one perpetrator and a series of victims, and they set up a fund and sort of arbitrated that out. This is a little bit different scenario because you have multiple perpetrators and multiple victims from a variety of walks of life. So there isn't quite that natural comparison in my mind to say that this is going to work, right? So I have a little bit of apprehension there. I also have some concerns about and I think Carolyn Zirk did a really good job of sort of saying this idea of like, we're going to take taxpayers' money to put in a fund to pay sexual abuse survivors who are also taxpayers who are paying into that fund. But like, it just feels something feels a little off about that for me. And so I just have a hard time kind of wrapping my head about that. But I think the other piece for me is like access to justice is a real desire, right? And I think for a lot of people, that's in the court. Like that's actually being able to go in front of a jury of your peers and say, this is what happened to me. And this is, how I feel like, and this is the evidence, and having that jury decide whether that's enough or not. Right. And I don't think we should take that option away from folks. I think that to me, once again, feels like us saying this is what's best for you. And I have a kind of a hard time with that. But I think the biggest concern I have is just for me, because I come at this from prevention, is I want disclosure. I want to know who else these people are in contact with. I want to know that I'm not talking about something that happened 50 years ago. I'm talking about people that are still abusing kids today who've been abusing them for 50 years. Right. And so that piece for me, I don't want to lose that in that process. So I'm not a lawyer. I'm sure there's a much more lawyerly answer to your question, but just as someone that's worked in the sector and worked with survivors, that's my take on it.
That's what I wanted. Thank you.
Yeah.
Excellent. Thank you, Senator Washington. Additional questions from the committee? Thank you all very much. Thank you. All right, we'll now go on to Teresa Lancaster. We have Kenneth Phelps Jr. That's fine. That's right. Yeah, sorry. Kenneth is coming up. Is that Kenneth? No, I already called Angelica Bailey. I'm sorry. And Kobe, I already called Kobe. He's not here. Is Kobe Little here now? Or is he? No. Okay, so Miss Bailey's not here. So then we have two virtual. So we can do Matthew Wolf and Elizabeth Letourneau.
Elizabeth's not here, but there's
Matthew.
Here and she's virtual.
All right, let's do that. Is anyone else from the virtual?
Yeah.
Janice Tucci. You put Janice in as well.
Yeah, they're both up.
Okay, great. Hey, Mr. Wolf, we can see you. You're up. Welcome.
Great, thank you. My name is Matt Wolf, and I'm a survivor of child sexual abuse. Such a simple sentence to share, only 14 words. You'd think it'd be easy to say, but it's taken me nearly 30 years to find the courage to share my experience. I can't speak for all survivors, but I know that for many adults like myself, my abuse is a secret that weighs heavily. For many survivors, our abusers walk free, or the institutions that enabled the abuse are not held accountable. Ultimately, I waited till my 40s to speak publicly about my abuse because it's re-traumatizing to talk about what happened, And the idea of being vulnerable and opening up about the abuse is terrifying. But the simplest explanation is I wasn't ready. My abuse happened at the hands of a trusted teacher coach. I was tricked into believing I was his only victim. I had to watch friends and my school community memorialize his memory at his passing. Even after 30 years, I'm still a kaleidoscope of emotions on the topic: angry, disappointment, embarrassment, and fear. Now imagine holding all those emotions in for 30 years, finally find the strength to come forward to try and hold accountable those responsible, only to be told you waited too long. We're sorry, but too much time has passed. Reforming the civil statute of limitations is critically important for survivors of abuse because we all heal at different speeds. This isn't like a broken leg where there's an understood timeline to repair. Sexual abuse impacts us all in different ways. So allowing men and women to make the transition from victim to survivor at their own speed when they are ready is the compassionate and morally just course of action. For these reasons, I respectfully urge a favorable report on SB 686.
All right, thank you very much, Mr. Wolf. We'll now hear from Ms. Sartucci. Janice, you're up. Welcome.
Hi, can you hear me?
We can, yes. Welcome.
Okay. Thank you. Thank you for the opportunity to speak today. I'm Janice Sartucci with the Parents Coalition of Montgomery County, and we've been following cases where children have been sexually abused by teachers and staff in Montgomery County Public Schools for about 12 years. There's been a lot of talk about children today that were sexually abused by adults in their schools many decades ago. But now let's talk about the here and now. As recently as 2021, another child sex offender was shown to have been employed by Montgomery County Public Schools for 25 years, known to be a sex offender, and left in MCPS classrooms. You probably aren't familiar with the MCPS teacher, Richard Shearer. That's because the victims of this child sex offender never had their day in court. The crimes were never reported or prosecuted. We only know about them now because the Buffalo, New York FBI, nobody around here, released the previously secret MCPS personnel records of this offender in 2021. The Buffalo, New York FBI press release is in my packet. MCPS has never reached out to the victims of this elementary school teacher or reported these crimes. Victims of Richard Shearer can still be in high school today or have just graduated. Victims of sexual abuse in Montgomery County are told that MCPS administrators will handle it, and they are not to contact police independently. What would keep a family from reporting their child had been sexually abused in Montgomery County Public Schools? Well, Montgomery County. As recently as 2016, Montgomery County State's Attorney was not redacting the names of children, little children, who were victims of sexual abuse in MCPS from the public court records. Imagine your child's name being permanently reported in public court documents as a victim of sexual abuse when they are 6 or 7. I can show you the files. And imagine that you do get up the courage to report the sexual abuse of your 7-year-old and the offender is arrested and tried. Your child will be put on the stand in Montgomery County in open public court, and their real first name will be used. This is exactly what happened in the week-long trial of MCPS elementary school teacher John Vigna. Covering up crimes against children is costly to classrooms and to children's lives. Will this be the year that the Maryland legislature decides to put children first? Thank you.
All right, thank you very much. Seeing no questions from the committee, thank you all for your testimony. Thank you. All right, that'll conclude the testimony for the proponents of the bill. We'll now switch to folks who are just going to testify to provide information. So if Mr. Kress would like to come up, and we have Mr. Nagel, Milton Nagel.
Good afternoon, Mr. Chair, Mr. Vice Chair, esteemed members of the committee. My name is Milton Nagel, the current Deputy Executive Director for the Maryland Association of Boards of Education Group Insurance Pool. And I'm here today purely on informational basis only to explain how most of the school districts in Maryland provide insurance coverage for their school system. The Maryland Group Insurance Pool was created by legislation back in 1986 and began to offer insurance products in '88. Over time, it's grown to encompass 19 of the 24 school districts in Maryland. all but the biggest ones are in the pool. The rest of them self-insure themselves. But in my opinion, and I worked for one of the member school districts for 29 years before retiring and now coming to MABE and serving as in this position as pool administrator. It's one of the best examples of what government does best. It allows entities of a like nature to come together to pool their assets, to create economies of scale, and to maximize the fiscal resources that are made available to them to put as many dollars as possible in the classroom where they belong. And in this case, securing the insurance coverage, and the key word is secure, because under the Maryland Tort Act, we have the sovereign immunity cap currently at $400,000. And so we self-insure that. We're large enough that we cover that internally. And the way claims come in, and we use a 5-year rolling average of what experience each member has, along with actuarial estimates of what what's called IBNR, incurred but not yet realized for existing claims, and actuarial estimates for what future claims may come in. We set rates for members to pay premiums in. And because we're self-insured, if at the end of any given year, claims come in at a rate less than what their actual amount was, they may get some money back. But that's a decision they make collectively. And it is certainly one of the best things. I know I've ran out of time, but with your privilege, a few more minutes just to provide the context here, that this is, how it is structured. We have already set the budget for FY24 because school system budgets have to be done and submitted to their county funding agency. In most counties, the school system budget represents the single largest portion of the county budget, in many cases 50% or so. And so county budgets have a timeline for their budget development, and the school budget has to be submitted in accordance with that county timeline. So we have our actuaries and our benefit consultants look into the crystal ball and try to forecast what rates should be, because we don't self-insure all lines of coverage. We don't self-insure property insurance, for instance, for buildings. And, God forbid a horrific hurricane come up the Chesapeake Bay and destroy multiple school buildings within our pool. We couldn't afford to handle that under our self-insurance mechanism. So we do purchase, property insurance, for instance, and we work with reinsurers for that. But for liability, which is what we're here to talk about today, we totally self-insure that. But we've already set those premiums for FY24 so that school districts can have some budget certainty. We are very sympathetic. As I said before, I worked for 29 years in a school district. We work very hard to make sure that our school districts do the right thing. And this Maryland legislature has passed laws in recent years that increase the scrutiny for which school districts have to go through to hire employees, to increase the amount of background checks that are done. It's important that we, children are the most vital asset. It's as a parent, when you say goodbye to your loved one in the morning, whether it's getting on the school bus or when they get out of the car, when they walk in that schoolhouse door, you expect them to come back in the evening, come back, period. Obviously we're not here to talk about active assailants, but to come back, period. But to come back in the same structure, physical and mental state that they were in when they left your care in the morning. We take that job very seriously. We employ risk management services. We have in-house risk managers that work with our member school districts on best practices, on trying to strengthen issues to help minimize the event of an incident occurring, because the best claim is the claim that never happens. And such is the case here. And we don't ever want to see these sorts of claims come forward, but when they do, now you know how we deal with them at the pool level. Thank you for your time.
Thank you, Mr. Chairman, members of the committee. Bill Kress here on behalf of MABE's liability pool and insurance programs. Mr. Chairman, I wanted to thank you for your generosity and your time you spent with us to go through the bill. I understand your commitment. I know it's been some difficult testimony today. I wanted to talk about the cost of this bill and the impact on the public entities, in particular the school boards. I got the fiscal note today and I was shocked that there are no numbers in the fiscal note. When you look at the fiscal note, it says that you cannot determine the amount of claims that will come forth if this bill passes. So that should give you a little bit of pause. And really my testimony is probably better served for a budget committee. But it's an issue that you should at least consider with this bill. We took a look at a kind of the back of the envelope kind of numbers and try to calculate what the cost might be. Because of your language in the bill that seems to indicate it's a single occurrence, so multiple incidents could be $850,000 for a school board. When we look at our experience over the last few years, it's not inconceivable to have 3,000 incidents that might come to fruition if we have an indefinite look back. 3,000 incidents would pencil out to $2.5 billion in a maximum judgment. It could be 1,000. At that point, it would be 850 million. We're not here to take a position on what the right number is or how you should proceed. We want to let you know that there are serious cost impacts to the locals. I did want to touch on two other issues rather quickly with respect to drafting of the bill. Under the Maryland Tort Claims Act, there's a cap on attorney's fees, right? 20% for trial, I believe, or 25% for trial, 20% for settlement. The school boards don't have that benefit. So we would ask that you look at that issue. The second issue is the language that requires the school boards to have $850,000 in insurance policies. So the way the statute works, we have sovereign immunity up to $400,000 or up to the limit of our insurance policy. So the way it's drafted, even though you've bifurcated the two levels, we would then have liability for $850,000 for all claims, not just sexual abuse claims. You would need to kind of split that out in the language. Those couple of things come to mind. Finally, just a quick note on Senator West's thought of a fund. It occurred to us that if you're going to move forward with this is something that might be worthwhile considering. There have been special funds set up to adjudicate claims in administrative fashion where you then have the ability to appeal the decision and you could have a special master. At the hearing those cases and making determinations as to compensability of claims, you could make it in an efficient manner. You could have attorney's fees limited. You could still have the right to a jury trial and appeal. If we're right, then there's going to be a lot of claims when you have an indefinite look back. This might be something that you should give some more thought to. So with that, I'll stop. Thank you.
Thank you, Mr. Chairman. So let's talk more about these insurance policies. Currently, the cap is $400,000. Currently, the cap is $400,000.
Yes, sir.
And that means what? That you buy $400,000 of insurance?
No, we self-insure that.
You self-insure
We self-insure.
400,000.
Yes.
And can someone get a judgment for more than 400,000?
Currently, no, sir.
Okay.
Not in state court.
So, all right. So under this bill, you would self-insure for $850,000.
Yes, sir.
So that means that the liability of any particular school system for any particular claim would be more than double in the future what it is today.
Yes, sir. Correct.
Okay. And is that, Mr. Kress, what you were talking about when you said you'd costed it out and it was around $2.5 billion?
Assuming 3,000 incidents.
Assuming 3,000 claims.
Right.
Okay. What about these numbers are based on the current system of law in which a person cannot go back indefinitely and file claims for something that happened 65 years ago. So what would happen to this system if we were to pass this bill and allow a 90-year-old to file claim for something that happened 80 years earlier when he was 10 years old, where everybody's dead and it's just going to be him sitting there on the stand telling his story to the jury? How would that affect the cost? How would that affect the cost to the various county school systems?
Adversely.
Well, So could the schools buy tail on their insurance policies, which would go back 80 years?
I'm not aware of any ability to purchase insurance retroactively. You can only purchase insurance prospectively. I'm not aware. Honestly, I was a trustee for a school district.
Right.
I'm not a licensed insurance broker. So I can't, definitively answer that question.
But to your knowledge.
To my knowledge.
No insurance company.
You can't buy the tail
sells the
for
tails.
in arrears.
So for example, using my example, the dental practice a while ago, if the current owner of the dental practice wanted to protect himself, he would not be able to buy a tail, which would protect him from claims made about things that happened from his fourth predecessor owner back in the 1950s. To the best of your knowledge.
To the best of my knowledge, no, sir.
Okay. Okay, thank you.
Thank you, Mr. Chairman. Thanks for coming forward and testifying. I just have a quick question because I want to know, do the rules of evidence still apply in these civil cases?
Yes.
So for the scenario that Senator West gave about a 90-year-old subject coming forward, he's 80 years ago, he's saying that this happened, and then he's saying that all the witnesses and everyone else have passed away. Is there still not an incumbent responsibility that follows the rules of evidence and discovery that would be required in any civil action?
Senator, as a somewhat reformed attorney, I guess I'll try to answer that. Yes, you're absolutely right. We're not here to take a position on how you should proceed with these cases. We're just.
Well, I'm simply pointing out that in the scenario that I just heard, that it seems like maybe a little. I just take exception with the idea that there's a feeling that's being presented potentially that anybody would be able to present a case or file suit willy-nilly without having any factual data or evidence to support such a claim, when there's actually a requirement in civil actions that there has to be a preponderance of evidence and that it has to be able to be substantiated.
Well, so to be fair, anyone can file a complaint.
I understand.
Anyone can file a complaint. To have a verdict issued in your favor in a civil matter, it's preponderance of the evidence.
Correct.
And
so there is evidence.
I was not here today to get into the debate about trying cases, but I will tell you as a former insurance defense attorney that the older the cases are, the staler the cases are, the more difficult it is to get actual facts put into evidence because people are gone, memories fade, things of that nature. But again, that is not why I'm here today.
I understand, but I want to understand. So you're saying what I think you're saying, which is as the older the cases get, it's difficult as the plaintiff to have evidence there, especially unless it was known about all along and there's a long list of infractions or violations or assaults that occurred, then the evidence would speak for itself, would it not? It wouldn't be somebody at 90 years old saying, feel sorry for me. I was violated, I was sexually abused 80 years ago and take my word for it.
So
that's not how they're adjudicated, correct?
Well, I mean, they're adjudicated and you present the evidence, whatever the evidence might be. The trier of fact makes a decision, and it may just be the plaintiffs, or it could be numerous witnesses. It could be a document case. It could be many things.
Sure. And what is the difference in proof beyond a reasonable doubt versus a preponderance of evidence? Going back to your
like law school.
Yeah. I'm not even smart enough to have my law degree. I'm just smart.
The easiest way to say it is preponderance of the evidence is slightly more than half, right?
Right. So
beyond a reasonable doubt is a little more sophisticated nuance as to what that is. We don't really.
Beyond a reasonable doubt shows that there is evidence substantial to convict that this person was associated for this wrongdoing, correct? That's a criminal requirement. The proof beyond or the preponderance of evidence is simply more than 50%. If you engaging in that there is reasonable belief that these offenses occurred through the evidence. The evidence is what I keep saying here. I'm just trying to make sure everybody understands that I don't hear a lot, and I did step out, so if I'm wrong, but I haven't heard a lot of people talking about, they're talking about presenting this and 90 years later, and that we'll go back and have these issues with the churches or the schools. But the reality is, we're talking about that there's a responsibility on the plaintiff as well as the defendant that there would be a preponderance of evidence exists to adjudicate in either direction, correct?
Yeah, well, the plaintiff would have the burden to produce the evidence.
That's even makes this case even, in my opinion, easier. The plaintiff has the responsibility to provide such a preponderance of evidence. That's what I was getting at. So thank you. I appreciate it.
Certainly.
Either want to be on the spot. So, but what my colleague here was suggesting, really, I think the greater issue might be whether or not even just being sued or giving a notice of suit, which in and of itself triggers an enormous amount of legal costs. And then the tough decision about whether you would proceed to trial or settle. I've done insurance defense work for a very long time. So my real question here, because I don't want to, we all know that's a risk here, but I'm just curious, because I was thinking there are other cases that are affecting state governments and local governments in Maryland across the country with this problem of getting lawsuits, state and local governments fearful to go to court, and then they pay out settlements, which, by the way, we all pay because it's taxpayer dollars. So no matter who sues or how it proceeds with the in the public sector, taxpayer dollars will be paying for all the claims that could arise here that are brought against the state and local government. It will not be private sector. But the question I have for you is, are you seeing in your global perspective that you all are pressed into settling more cases than you are comfortable with, but you make it because lawyers like me come and tell you that it is less expensive or too risky, even if you feel confident in the facts that you have? Is that been an issue for you? And it may not be. I just do not know, and I wanted to ask.
Unfortunately, it's a business decision, and the business decision is always to weigh the cost versus the benefit. And certainly you look as you move through discovery, different phases of a case, what is the total cost of this case versus the potential to either win or lose. And different jurisdictions have more sympathetic judges and juries, depending on what type of trial it is. And so a lot of thought goes into whether, and in our case, direct correspondence with the affected member as to how to proceed, whether to try to settle or proceed to go to trial.
Because there are areas in which I'm just going to inform the committee. There are a multitude of businesses and others that routinely settle for fear of going to court, and their insurance and other costs go way, way up.
And quite honestly, in this context, in this very sensitive matter here of sexual abuse and molestation, we also take into account the victim and not wanting to put a child on the stand.
Right. Again, that would be, you might settle.
Yes.
And the cost.
Because the family doesn't want that.
Exactly.
I mean, they don't want that in most cases.
Which in a way kind of militates toward my good friend Senator West's idea of perhaps approaching this in a different way with a fund. All right. Thank you, gentlemen. Thank you.
Yeah, thank you, Mr. Chair. I won't belabor this, but Mr. Kress, you were an unwilling witness a few minutes ago. So I'm going to ask you more questions, 2 or 3 questions along the same lines. Let me give you a hypothetical. There's a 90-year-old man. He files suit against a parochial school, claiming that when he was 10 years old, he was abused by one of the administrators of the school. The administrator is dead. In fact, everybody else who was in administration of that school 80 years ago is dead. No documents are extant which have any bearing on this at all. So there is no human being who can testify on behalf of the defense and shed any light on what happened. Is it not true that under those circumstances that the plaintiff would be able to sit on the stand, take the oath, and tell his story? The story itself is evidence. Human testimony is evidence. And therefore, at the end of the case, if the defense has really nothing they can offer other than trying to impeach the credibility of the 90-year-old man, is it not possible that the jury could be sent back to the jury room to render a verdict and could come forth rendering a verdict in favor of the plaintiff for some amount of money.
That would be correct. You would meet your burden of production, I would think, and it would go to the jury.
Thank you.
Yeah.
Thank you, Mr. Chair. So I heard you guys make a wonderful comment about, I'm not going to continue to belabor the issue about someone's credibility on the stand and giving a statement from what happened 80 years ago. That's just, to me, that's ridiculous. I'll say that right up front. Is it go into evidence? Yes. And then do they get to come back and counteract it with the same type of, well, we were there and it didn't happen. I'm not going to get into that. What I want to get into is, you guys or somebody made a comment about that they would, it was a noble statement that instead of putting a child through that, they would probably settle the claim. Would your clients settle a claim, or would your organization that you guys represent settle a claim that and can prove is false to protect putting a child through testimony? And I have a really good idea what that answer is, but I'd love to hear it from you, because that's really noble, the statement I heard a minute ago.
Good.
If beyond the shadow of a doubt, we know that that teacher or that staff member is innocent and the acts were not committed, then yes.
Isn't a component of this legislation, though, that you had to have known and allowed these acts to exist? Isn't that a component of this, what this law talks about?
Yes.
This legislation? So if you have known about it and a lawsuit comes forward, that's what this is about. Being able to seek damages subsequent to that. Is that not correct?
That's part of the defense, proving that we knew about it.
Correct.
That doesn't stop a plaintiff from bringing forth a case.
I understand that. But we went into the whole legal matter of what is preponderance of evidence versus proof beyond a reasonable doubt. And what I'm asking you is if you know that your employee had nothing to do with the alleged allegations and there is no evidence to support that claim.
Then yes, and I answered that. Yes, sir.
Are you gonna pay out to not put the child through it?
No.
You're daggone right or not?
That's correct.
So I don't like when we sit here and we're trying to put that we're being very noble in response to the kids and not putting them through stuff or re-victimizing them. When that's not the case. It's about the dollars and cents. If they can't prove it, we'll defend it. If there's a reasonable doubt in your own mind, then we might settle.
Yeah, I got it. No, there's too many scenarios there, and
I get it.
There are lots of terms for settling, for NDAs and all that stuff.
To clarify,
people settle for all sorts of reasons to protect from all sorts of perception. No, I got it. I know. I just hard to kind of. It's hard to square that peg.
Where there's a preponderance of evidence to support the claim, sir.
No, I get it. Yeah. No, I get it. All right. Yeah, I appreciate the information. We will continue, if you are amenable to consult to understand. I think it's important for all of us, is policymakers to look problems in the eye and to understand exactly what we're doing. And so to the extent that you can help and continue shed light on what that looks like, I'm tremendously appreciative. So,
that's why we're here today.
Yeah, exactly right. I know you're not taking a position on the merits of anything. You just kind of explain what the field of play looks like. So I appreciate that. Okay. Thank you very much for your testimony. We have one person signed up in opposition, which is Mr. Silverman. I think I see him back there. Mr. Silverman, come on up.
Good afternoon, Mr. Chairman and members of the committee. Thank you for the opportunity to testify today on this very difficult topic. My name is Kerry Silverman, and I'm here on behalf of the American Tort Reform Association, which is our focus of the group is on maintaining a balanced and predictable and properly functioning civil justice system. And we've worked on this issue, unfortunately, in a number of states. ATRA doesn't oppose having a lengthy statute of limitations for childhood sexual abuse survivors. We have concerns with the approach that's taken in this bill, however, and I'll summarize those briefly, and we'll welcome your questions, whatever they might be about the constitutionality or what other states have done. I can hopefully provide a little perspective on that if it would be helpful. Our concerns are, number one, with the complete elimination of the statute of limitations entirely in this bill. That's an unprecedented approach. It's not anywhere else in Maryland law. And there's a critical purpose to having statutes of limitations. And my testimony today would be the same for any type of civil claim where we were doing this sort of approach. We have those statutes of limitations. They might seem arbitrary, but they're there so that judges and juries can decide and evaluate liability when we have the records available, when we have the evidence, the witnesses available to testify and come to the right conclusion on what occurred. It's never easy to tell someone that the time to sue is past, regardless of whatever type of claim it is. But there's a reason, and that's the reason that we have statutes of limitations for every type of civil claim, whether it's a person who was run over by a drunk driver or whether it's a person who was maimed by a defective product. We have a statute of limitations that's finite. Our second concern is the retroactivity of the bill, which really exacerbates the first. There's no doubt in these types of cases, I think, that the survivor, the plaintiff, has experienced horrific abuse. That's not going to be an issue in most of these cases. The question in these cases is whether a public school or a nonprofit or a business 40, 50, 60 years ago, they had the proper practices in place to prevent it. It's negligence. And it's not a did you know? It's not a known, did you know of the abuse? It doesn't require that. It doesn't require concealing the abuse. All it requires is showing that they should have known or should have done something differently all those years ago. So we support extending a statute of limitations if you feel that that is necessary, but we feel that it ought to be finite and that it should be prospective. Thank you.
Excellent. Thank you very much. Question. Senator Sidnor has a question.
Thank you. You said that it should be finite. Do you have a statute of limitations for us?
I'm sorry, I didn't hear.
You said it should be finite.
Right.
Statute of limitations. Do you have a number for us?
I don't have a specific magic number for what it ought to be. I think that's to your legislative judgment. You now have a statute of limitations of 20 years that runs from age 18. So it's a significantly longer statute of limitations than for other personal injury claims. But if you felt that a longer period was needed, that would be for your judgment. I don't have a number.
But you are in agreement that if we want to change it, we certainly have that authority to do so.
Certainly prospectively.
Thank you.
Questions from the committee? All right. Thank you very much, Mr. Silverman. Thank you. All right, with that, that'll end the testimony and the hearing for Senate Bill 686. Before we gavel out for the day, I just want to take a moment to say thank you to all of the survivors and the advocates that came out today. This is a number of years in the making. And so I just want to say, from the committee, from me, thank you for being here. I know that this is an arduous experience over and over again coming down here. So just really appreciate you sharing your perspective and taking the time out of your lives to come down here to testify. So thank you very much for that. And with that, we'll gavel out. Have a good evening. Tomorrow we have 9 a.m. voting. 9 a.m. voting.